yesterday?
Lordship, the application has been assigned before Justice Rao.
Milord,
With the interim order.
And you mentioned what
Yes,
is mentioned
Lordship.
on to yesterday itself.
Yesterday only.
yes, Milord, everything has been done. I went to Justice Justice Sujoy Pal's chamber. Milord got it assigned, and Milord, it was extended at 5
That's
past
all
5.
right.
Yes, Lordship, it was accepted.
Purpose
may I
of
have-
that's all.
Obliged.
I'm so sorry. I'm so sorry, Mr. Mitra.
We are grateful.
And I'm so sorry. And the order I have sent, it is almost a handwritten order. With all corrections, I have signed it.
Your Lordship's initiative, we could not capture it.
No.
We are great.
I'm so sorry, but I should not have taken that. কাজ হয়ে গেছে চলো সেটুকুই দরকার দেখি one second এইটা ওখানে রেখো না এখানে দাও yes
Milord, item number
senior is there
Milord, may I minus kindly to mention item number 20 and 40.
they are
Milord,
also to be released.
Milord, yes. Milord, I found that minor had appeared in 20 and 40.
20
And 40.
Wait 20 JCC
and 40
and 30 and
40.
I appeared
Yes, I ordered ta dekhiye. May I show the order, Milord? I'm carrying the order.
Who disbelieves the member of the bar? Thing is that both the sides should not face any embarrassment at any point of time. That's all. Because this it's a joint family. That's all. দেখো 20 আর 40 দুটো একসঙ্গে অর্ডার করে দাও না দুটো আলাদা আলাদা করো যেমন আছে 20 তে করো the matter has been mentioned by Mr. Nirmallo Dasgupta, learned advocate, appearing through virtual mode on behalf of plaintiff. Paragraph. Since I have appeared in the matter.
Not in this matter, Lordship.
All right. Due to
for the plaintiff, my lord had appeared.
Group of companies.
Right. No, for the plaintiff only, my lord had appeared.
Oh, for the plaintiff.
Not in this matter.
All right.
Another suit.
All right. Since I had appeared for the plaintiff, whilst in the bar, the matter stands released from my list. Paragraph. Records are directed to be sent to the Secretariat to the Honorable the Chief Justice for taking steps for assignment. Same order করে দাও নীলমাল্য দাশগুপ্ত আর প্রিয়াঙ্কা ম্যাডাম আর ওই মিস্টার মিত্র একসঙ্গে ওদের নাম দিয়ে দাও যা দিচ্ছেন ওনারা লিখে দিও ঠিক আছে
Now I am starting to prepare a list.
No, yes, I am relieved. You are also relieved, Mr. Mitro. That tension, I was feeling so bad. Let me tell you, I was suffering from my pricking of my conscience. That I have heard 1 hour. Whatever way it will come. But so I was really upset. But very well, it has to be.
God's grace and your Lordship's good wishes, we could succeed.
Thank you, purpose, whatever. Litigant should not suffer, that's all. Take the microphone.
May I have your Lordship's kind leave to, I'm mentioning 3 analogous suits, similar suits for extension of time to complete witness action by commission. It is expiring on the 28th of November, your Lordship.
To be mentioned?
To be mentioned, your Lordship.
Tomorrow?
Lordship, any day.
But where are the defendants?
I'm mentioning upon notice, they are on notice.
So, not required. Since you are making this submission, that's good enough. Who will disbelieve? The bar? But give notice that it will appear tomorrow. Inform them, bring them, I will extend.
Grateful.
Paper gulo আনতে হবে? When it is expiring?
28th of November.
আজকে কত? তাহলে 2 দিন সময় দেওয়া যেতে পারে because the papers are not there.
Very well, Lord. On Monday.
এটাকে এক কাজ করো Monday করে দাও to be mentioned.
Mr. Mitra and I both are appearing in the matter. We are both
yes.
today.
It's a pleasure to hear all of you.
With your Lordship, please, may
especially the juniors.
With your lordship, please,
Yes, yes.
may I be permitted to mention a matter for extension of interim order. The interim order is valid till 20th November
আজকে কত
19.
19 কাল অবধি tomorrow till
Yes, your
tomorrow.
lordship.
To be mentioned tomorrow.
Great.
Interim order, huh? এ লিখে দাও extension of interim order. To be mentioned tomorrow. Yes.
Well, I am for the plaintiff. This matter is appearing at my instance. Well, there are two typographical errors in your lordship's order, my lord, dated 17th of November. Well, the first one is at 4th line.
Give
Well,
me,
fifth
give me,
line.
give me copy. Oh. Yes, it should be 1 crore 25 lakhs.
Yes, my lord, that is one. And my lord, instead of defendant number 2, it should be defendant now. My lord, the defendant number 1, it should be defendant number 2.
We are for different number.
Maybe returned back to defendant number 2.
No, my lord, party is
Deposited by-
informed to this court that the defendant number 1 has never entered appearance. It should be defendant number 2, my lord.
We are for different number 1, your lordship.
But defendant
never-
number,
So defendant number 2 has never entered
my lord,
appearance.
my lord.
And the rest is fine.
Rest is
Defendant
fine.
number 1
And my lord, 1 crore 25 lakhs, my lord.
that's right. Wait. কার ছাপা এসবি ঘোষ দিদি লেখো
No question about
The matter has appeared under the heading to be mentioned at the instance of the plaintiff,
my lord.
comma, as there is an apparent typographical mistake on the face of the order dated November 17, 2025. The full stop. The first paragraph, the first correction is it should be recorded and read that defendant number 2 has never entered appearance, right?
My lord.
In place of defendant number 1. Paragraph. The second correction is the quantum of money should be corrected and read as bold 1 crore 25 lakhs. 1 crore 25 lakhs. যেভাবে লিখে সংখ্যায় লিখে দেবে ঠিক আছে ব্র্যাকেটে বানানে লিখে দাও 1 crore 25 lakhs bracket close instead of 1,25,000. Hello. Paragraph. These corrections should be incorporated and read into the order dated November 17, 2025. And today's order shall be treated as a part and parcel of the earlier order.
My lord, one more
Said earlier order.
one more indulgence, my lord. This suit is with regard to infringement of copyright, my lord. So in all probabilities, my lord, we should have indicated to lordship this yes, my lord.
IP.
IP, my lord.
Then why?
My lord, the numbering has not, there is no IP com number, my lord. It is running as, my lord, CS com. This matter is a very old matter, my lord.
Paragraph. In addition, both Mr.
My lord, Tanmoy Roy.
Tanmoy Roy, learned advocate appearing for the plaintiff, and Mr.
Devanshu Dinda,
Devanshu Dinda, learned advocate appearing for
different number 1.
defendant number 1, submit that the instant suit arising out of infringement of copyright, and accordingly the same shall be placed before the designated bench
Well.
for the same.
Grateful, my lord.
Paragraph. Due to want of determination, the instant suit with all connected applications therein are directed to go out of the list of this court, are directed to go out of the list of the commercial court, commercial division, list of the commercial division, and shall appear before the designated bench taking intellectual property matters.
Grateful, my lord.
The
Three number.
Your Lordship, the department.
My lord,
বুঝতে পেরেছো? বলো কোথায় কোথায় বুঝতে পারোনি। Clear?
Your Lordship,
My
what
lord.
it does is the suit has to be renumbered as
Paragraph, the registry is directed to re-register, to change the number of the plaint, by converting it
IP.
accordingly.
great.
Paragraph, the suit register also be corrected accordingly.
Great.
I appear for the plaintiff for opposing the application.
My application, my lord.
Judgment is-
I had more or less placed the application.
But I'll make very short submission. But,
এই অ্যাপ্লিকেশন লিস্ট সরিয়ে দাও। ওখানে কেন নিচে রাখো না, আমার সামনে কেন? Yes,
but application is for production of additional documents at the stage of trial when the defendant's examination was going to start. But my learned senior friend has placed
দেখি
the
দেখি
application.
দেখি 1 মিনিট। অর্ডার দুটো
কালকে একটা অর্ডার হয়েছিল।
Order 8 Rule 1.
Order 8 Rule 1A and Order 11 Rule 1
Sorry,
Subrule 10.
sorry.
Order 11, my lord.
I'm sorry.
But Order 11 Rule 1
Wait,
Subrule
wait,
10.
wait. You have cited 2025-8.
No.
I cited
Acha, 1 second.
2021 Volume 13 SCC was cited.
and
2000?
2021 Volume 13 SCC was cited. Sudhir Kumar.
2021, 13 SCC, page 71.
দেখি দেখি।
Judgment গুলো দিয়েছিলি তো কালকে? দিয়ে দিয়েছি। And I had also relied on 2020,
2020.
10 SCC 70.
Oh yes, got my note. Let us narrow down the scope of the application.
Yes, my lord. There is, my lord,
We will only see that whether sufficient cause has been made out or not. Because the statute provides for the provision,
yes,
right?
yes.
So if sufficient cause, that is the perception of the court, varies from each court to court, and it is the discretion of the court at the same time to a large extent.
Right.
Right?
Yes, my lord.
Yes.
But the only explanation which is given, the sufficient cause, my lord, which is the cornerstone, my lord, that appears at paragraph 16 at page 6 of the application.
Acha, let me see.
Paragraph 16, subparagraph A to C.
Paragraph 16.
Yes. My learned senior friend had placed it. Lordship,
One second.
shall once again, my lord, go through.
Paragraph page.
Page 6 of the application.
Yes. Yes, sir.
Now, at the time of preparation of the affidavit of examination in chief of the
You
defendant.
have used affidavit.
Yes, my lord, affidavit.
Show me that.
Right, in the affidavit, I've taken this point. My lord, two grounds have been taken. One is a technical ground, which I'll not press, and the other ground is that.
Let me see your affidavit. Bikash Boisho.
Yes, that he's my advocate on record. Paragraphs 3 and 4, these are my two defense.
Paragraph
3 and 4 of my affidavit in opposition.
Saurojit.
Yes,
Saurojit
Dashgupta.
Dasgupta. এই ঘরে এসি চলছে না? একটু লোক ডাকো তো, এসির লোক ডাকো, এসির লোক ডাকো। আজকে তারিখ কত?
Today is 19th.
লোক ডাকো তো এসি।
Paragraph 3, Lordship may ignore. That's a procedural point, technical ground, which I'll not press. I simply said that it ought to have been filed as a chamber application with a master
Forget it.
summons. Yes, man, I'm
It's
giving
now
it up.
mixed, all mixed. I
Yes,
cannot disagree.
I'll not urge that ground
Acha.
at all.
Paragraph 8.
Paragraph 4, my lord.
4.
4 is where I've stated, but I'll place the paragraph. Without prejudice to the above, I say that the application is also not maintainable and or impermissible in the facts of the case. Defendants have sought to file this application for the purpose of disclosing further documents which have been annexed as Annexure K.
Wait, little slowly.
Right, sorry.
Defendants have sought to file this application, blah, blah, which have been, read on,
But which have been
annexed.
which have been annexed as Annexure K to the said application. In paragraph 16 of the said application, the defendants have sought to explain the reasons for not disclosing the said documents at the time when the written statement was filed. Admittedly, the trial of the instant suits has commenced and the evidence of the plaintiff has already been concluded. Now, paragraph 5.
The trial commenced and
Trial commenced and the plaintiff's evidence has already been concluded. Thus, in view of the restrictive or prohibitive provisions of Commercial Codes Act amended by Code of Civil Procedure, no documents as sought by the defendants can be permitted to be disclosed in this state. There is also no foundation pleaded in the written statement which suppose the document which the defendants have now sought to introduce in the suit.
you tell me, is there any statutory bar at after what stage this cannot be done?
During trial, it can be, provided sufficient explanation is
That's
granted.
I tell you why. Like amendment of pleading.
Yes.
It says at any stage of the proceeding. All right, then
But I am simply saying that in paragraph 16 of the application, which is the explanatory,
sufficient ground.
firstly, not sufficient. Secondly, it does not satisfy the preconditions here because admittedly, the documents were in power and possession control of the defendant. The defendant is saying that the defendant found those documents in its own office. So it can't be said that it was not in the power, possession or control. So that is why I say that, and this suit is of 2019. The written statement thereafter, applications after applications were filed, affidavits exchanged, disposed of, part decree was passed on admission, and thereafter this written statement came.
Part decree passed.
Part decree passed. It's a judgment on admission was passed, and they have already satisfied that judgment, that decree. They have paid part of the amount which has been claimed in the suit.
Judgment upon admission passed.
For part of the claim.
Huh. Yes.
Written statement was filed on 26th April 2022.
Written statement filed on
26th April 2022.
right.
Now, after 3 years, they are coming and saying that is this a sufficient? Can this be permitted? That is what your lordship would decide. Now, lordship may exercise discretion and see whether the documents were in control of the defendant or not. This has admittedly has not even been argued that it was not within the control. So, pleaded cases.
No, she also says that it is within his office.
Yes, pleaded. Specific case.
Absolutely.
So, in those circumstances,
Whether
it cannot be because this is not a. I would have understood if the documents had not been in possession or surfaced after the filing of the written statement. Or while preparing the written statement, it was so urgent that those documents could not be annexed with the written statement. Now, my lordship will see in the amended provisions, order 11.
Yes.
There are prohibitions. Sub-rule 10, rule 1, sub-rule 10, may I place once again?
1 second.
Rule 9 and 10, I'll place.
Yes.
Rule 1, sub-rule 9 and 10, if I may place.
এই শোনো, কালকে যেটা ওই একটা সার্ভার হয়েছে, সেই অর্ডারটা তুলেছো এখানে? একটা কালকে সার্ভার হয়েছে কাউন্টার ক্লেমের উপর, দেখি। দাঁড়াও। হ্যাঁ, তোলা আছে। Yes. Sub-rule 9.
Sub-rule 9 and sub-rule 10. 10, lordship has already perused one on the last day.
Let's read.
Yes, sub-rule 9. The written statement or counterclaim shall contain a declaration on oath made by the deponent that all documents in the power, possession, control, or custody of the defendant, save and except for those set out in sub-rule 7C3 pertaining to the facts of the circumstances of the proceedings initiated by the plaintiff or in the counterclaim, have been disclosed, and copies thereof annexed with the written statement or counterclaim, and that the defendant does not have in its power, possession, control, or custody any other documents. Now, this is a mandatory provision which one has to satisfy.
Declaration. It's a
Declaration that these documents are in power. I am annexing these documents, and these documents may have been in my power, but I am not annexing. That declaration can also be made. That is also permissible.
You are saying that in that declaration also they did not whisper of this document.
Yes, and
they are on possession. They are in
possession. They may have made a declaration that they think that there are other documents in their control which they may disclose.
Next.
That's sub-rule 10. Save and except for sub-rule 7C3, defendant shall not be allowed to rely on documents which were in the defendant's power, possession, control, custody, and not disclosed, along with the written statement or counterclaim, save and except by leave of court, and such leave shall be granted only upon defendant establishing reasonable cause.
Let's read it little slowly.
Yes. Save and except for sub-rule.
Yes, save and except sub-rule 7C3, which is not applicable.
Which is not applicable. The defendant shall not be allowed
to rely on documents.
Yes.
Which were in defendant's power, possession, control, custody, and not disclosed along with the written statement or counterclaim, save and except
by leave of court.
So it is not an absolute prohibition.
No, it is not an absolute prohibition.
It's not a prohibition at all.
No, it's not an absolute
Depends on the discretion and perception of the court.
Absolutely. My lordship is that is what the provision also says. But these are my 2 points. I'll rely on one judgment of the Delhi High Court. Reported in 2022 SCC Online Delhi 2099. 2022 SCC Online Delhi.
Wait.
Sorry.
2022 SCC Online
Delhi 2099.
ওর মধ্যে গেঁথে দিয়ে দাও defendant. Yes.
Kindly takes paragraph 6 or the first paragraph and then comes to paragraph 6. First paragraph, the impugned order dated 7th May such and such passed by such and such court in such and such suit dismisses the application of the petitioner under order 8 rule 1A of the civil procedure code and also closes defense evidence. Here the defendant moved an application.
It's from not allowing the written statement.
No, not further. The defendant's prayer was to adduce further evidence or disclose further documents.
Order 8 rule 1A, what does it say?
Duty of the defendant to produce documents upon which relief is claimed or relied upon by him. where the defendant bases his defense upon a document or relies upon any document in his power or possession in support of his defense or claim for set-off or counterclaim, he shall enter such document in a list and shall produce it in court when the written statement is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the written statement. Where any such document is not in the possession or power of the defendant, he shall, wherever possible, state in whose power or possession it is. A document which ought to be produced in court by the defendant under this rule, but is not so produced, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. Nothing in this rule shall apply to
But that is
documents such
on a
and such.
different.
That is on a different note.
That is during examination if he can realize.
If he can rely on documents.
Whatever.
Yes.
But that is not applicable in
No,
this
but
case.
this judgment also deals with the provisions of Order 11 as well.
Yes.
Order
Show
8,
me.
Rule 1A, as well as Order 11, Rule 1, Sub-Rule 10.
Show me.
But paragraph 6, the suit was filed as a commercial suit under the CPC as amended by Commercial Courts Act, whereunder an application for permission to place certain additional documents on record was moved.
Yes.
Paragraphs 3 to 7 of the said application, which set out the justification for the said press, reads thus. I'm not praising the justification pleaded in that application. Paragraph 8 summarizes the justification.
8.
8. Clearly, therefore, the only ground urged for the default on the part of the petitioner in filing the documents that it now sought to place on record, along with its written statement, was that when the written statement was filed, the documents were not collated.
Let's say identical.
Identical situation.
Then
my lord, paragraph 9 is the submission which is dealt with in paragraph 10. So I'll place paragraph 9. Mr. Malhotra, learned counsel for the petitioner, has sought emphatically to urge that the management of the petitioner, which was dealing with its affairs at the time of filing the written statement, was unaware of the documents which were sought to be placed on record under cover of the aforesaid application. That submission, however, would be contrary to the specific assertion in paragraph 4 of the application to the effect that the documents were not filed as they had not been collated. The very assertion.
yes.
But paragraph 10, my lord, is not very applicable to the facts of the case. Then paragraph 11 sets out the decision, the impugned order in that case. Then paragraph 12 is, as your lordship, my lord, noted, it was an application under Order 8, Rule 1A. But the trial court here held that it ought to have been under Order 11, Rule 1, and that is upheld by the High Court.
Then what is the ratio?
Then comes, my lord, paragraph 16 and 18. Clearly, in proceedings under the Commercial Courts Act, there is an absolute statutory proscription on a defendant being allowed to rely on any documents which were in its power, possession, or custody and not disclosed under the written statement or counterclaim, except by leave of the court. Court is also statutorily proscribed by Order 11, Rule 1, Sub-Rule 10 from granting leave, except where reasonable cause for not filing the documents along with the written statement has been made out. Then paragraph 17 relies on the Supreme Court judgment, which my learned senior friend has also relied on, Sudhir Kumar. Then paragraph 18, the only ground urged in the application filed by the petitioner to place additional documents on record was that at the time of filing of the written statement, the petitioner's affairs were being managed by an earlier management which had not collated the documents. This itself indicates that the documents were within the power, possession, and control of the petitioner at that time. Obviously, therefore, in view of the proscription contained in Order 11, Rule 1, Sub-Rule 10, the learned commercial court could not have allowed the documents to be brought on record, and no exception can, therefore, be taken to the refusal by the impugned order to do so. Mr. Malhotra has emphasized that the importance of the documents for a proper adjudication of the controversy. He has also submitted that bringing the documents on record would not cause any prejudice. Unfortunately, these considerations cannot be of any relevance where the suit has been filed as a commercial suit. The proscription against bringing additional documents, save and except where sufficient cause were not filing of the documents along with the plain written statement, In the case of the plaintiff and the defendant, as contained in clauses 5 and 10 of Order 11, Rule 1, as amended, are absolute. The court cannot dilute the rigor of the said provisions on any sympathetic or other considerations. It is presumed that these considerations were in the mind of the legislature when they enacted the Commercial Courts Act. There can be no charity beyond the law. As such, the challenge in this petition to the order dated such and such, insofar as it rejects the petitioner's application for placing the additional documents on record, must necessarily fail. Now, paragraph 23 onwards deals with the closing of evidence, not applicable to the case. Now, here, my lord, I am placing reliance on these
This was
paragraphs.
not found to be sufficient cause by his lordship,
Yes.
and then his lordship decided no, there is no sufficient. So, as I said, it varies from
Person to person. Yes, absolutely.
possession of court, from
Yes.
one court to other.
Yes. My lord, that is all. My lord, these are my submissions. Documents were in power, control, and possession. That's all.
My lord, my case was that these documents could not be filed because they were not able to locate it. My witness, when he was about to come and give evidence, he found these documents were missing. I have specifically said he conducted extensive search at the various offices of the defendant and thereafter located
What
the
is the
documents.
stage of the evidence?
My lord, my plaintiff has closed, mine has not begun. I have also not filed my affidavit of evidence.
So, it has not yet commenced.
No, my evidence has not commenced. But one more important thing is in the affidavit in opposition, paragraph 8, which deals with this paragraph 16 of my application, he has not denied that I had found it after searching. He has not said that.
That's not his submission. His submission is it was all along in possession, don't allow.
But it was in
The
possession.
defendant would have been more vigilant. That's his submission. All right.
My lord, another thing I would be submitting collate, my lord. The word collate means to organize so that I can my lord.
এসো, লেখো। This is an application filed by defendant number.
Defendants
All
1 to
defendants.
6. All the
Defendant
defendants.
number, all the filed by the defendants. With a prayer that the defendants can be permitted to disclose certain additional documents which were neither made part of the written statement nor have been disclosed by the defendants. First, the prayer paragraph, the prayers from the master summons or notice of motion. What?
Notice of motion.
Notice of
কোথায়?
But,
Notice of motion are quoted below.
but may I have your lordship's leave for some time? I'm so grateful.
Ask your junior if
Yes,
any
my lord,
assistance is
she's here.
required.
She's
কি বললাম? Quote 1. এটা না ফ্যাক্টস লেখো উপরে, ফ্যাক্টস করে এটা জাজমেন্ট হবে, আপলোডও হবে অ্যাজ জাজমেন্ট, ঠিক আছে? আর ফ্যাক্টস হচ্ছে এটা, হলো? The plea taken in support of the claim, the plea taken by the defendants in support of its claim are stated in the affidavit in support of the master summons. The relevant portion is quoted below. Quote paragraph 16 with all subparagraphs. Page 6. ঠিক আছে, কোড 2 সাব প্যারাগ্রাফ হচ্ছে A2F, কোড 2। Paragraph. The application has been opposed by the plaintiff. Full stop. Parties have filed and exchanged their respective affidavits. Full stop. The objection raised on behalf of the defendants would be available from the affidavit in opposition, which are inter alia quoted below. Paragraph 4, quote paragraph 4, 5, 8 from the affidavit in opposition. Four, 5, 8. ঠিক আছে বাবা? 4, 3, 4, 5 and 8. 4, 5 পরপর কোট করবে, মাঝখানে 2 লাইন স্টার 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 স্টার, তারপর আবার 8. কোট 3. Fine. Submissions. MS Ashnuhana Chakraborty Learned Counsel appearing for the defendants oblique applicants, relying upon the provisions laid down, relied upon the amended provisions laid down under Order Roman 11, Rule 1, to the Code of Civil Procedure, bracket CPC, submits that in view of the promulgation of the Commercial Court Act 2015, bracket for short CC Act, the amendment had taken place in CPC. Paragraph. Referring to Rule 9 and 10, Rules 9 and 10 to Order 11 as amended, comma.
Sub-rule 9 and 10. Sub-rule 9 and 10 of rule.
I'm sorry. Sub-rule 9 and 11, 9 and 10 to Rule 1. Sub-rule 9 and 10. এই sub-rule থেকে bold করো. Sub-rule bold করবে. Sub-rule 9 and 10 to Rule 1 of Order Roman 11 of CPC. এই অবধি bold হবে. As amended, comma. she submits that even if the documents referred to in her application are found to be throughout in the custody and control of the defendants, then also there is no absolute bar in disclosing those documents by way of additional documents, subject to the leave granted by the court. আচ্ছা, ওই ফ্যাক্টসে না সাবমিশনের আগে আর একটা লাস্ট সেন্টেন্স করো। The defendants have not yet submitted its evidence on affidavit. Full stop. The examination in chief of the plaintiff's witness, one witness.
One witness and
Any further witness? No further witness. The examination in chief of the sole witness of the plaintiff has been completed. Full stop. Who has also, who has also been cross-examined already. Full stop. At this stage, the instant application has been filed. কি বললুম? ওইসব হয়ে গেছে। হ্যাঁ, শেষকালে এসে। If affidavit of evidence আমি বলি না, it's evidence on affidavit. ওটা তো হয়ে গেছে, আমি লাস্টে এটা একদম এটা উপরে উঠে যাবে সাবমিশনের আগে। হ্যাঁ, এবার সাবমিশনের শেষটা বলো। ম্যাডামের সাবমিশন যেটা রেকর্ড করছো, একটু পড়ো, একটু আগের থেকে পড়ো। Sub rule 9 and 10, 2, TO2 rule 1 of Roman 11. Documents. Paragraph. Learned Counsel M.S. Chakraborty then submits paragraph এটা। Then with further reference to the relevant rules under Order 11 of CPC submits that if the court is satisfied with the explanations and the reasons shown by the defendants to be bona fide, just or cogent, the court can grant leave to the defendants to disclose the additional documents. Right? These are your submissions. In support, she has relied upon, you have relied upon two.
Judgments of the Honorable
In support, she has relied upon the following judgments of the Honorable Supreme Court. Colon, Niche, Roman 1. In the matter of Eta versus Eta reported at Eta Koro, or Eta versus Eta reported at Eta Koro. প্রথমে এইটা, তারপর ওইটা। এটা হচ্ছে D1, এটা হচ্ছে D2। প্রথমে সুধীর কুমার করো, তারপরেতে সুগন্ধি করো। প্রথমে সুধীর কুমার, তারপর সুগন্ধি। রিপোর্টেড এট 2021, আর পরেরটা কি আছে? D2, হ্যাঁ। টেন SCC 706, রাইট? ঠিক আছে, ঠিক আছে। Any other submissions you have made?
Regarding Sugandhi judgment, regarding Sugandhi 2020 judgment, I said that what is sufficient cause in that case, pressing out documents later was accepted as sufficient cause.
I have
My
said
lord
that.
has recorded, my lord. That's why I said.
So these are your submissions? Poster, paragraph. In the light of the above,
Foundation is there in the written statement. My written statement, the foundation for these documents, the pleadings are there in my written statement.
she further submits that the foundation of the documents, additional documents now sought to be relied upon by the defendants are already there in the written statement filed by the defendants. হয়ে গেল? প্যারাগ্রাফ। এটা একটা প্যারাগ্রাফ হয়ে গেছিল আগেরটা। প্যারাগ্রাফ। In the light of the above, comma, M.S. Hashnuana Chakraborty Learned Counsel, appearing for the defendants, submits that this application should be allowed. Paragraph. Par contra, Mr. Shourojit Dasgupta with M.S.
Ranjana Shil. Ranjana Shil.
Rachana
Ranjana Shil. SEAL.
SEAL, learned advocate, appearing for the plaintiff, submits that the applicant's case is throughout that the documents are in possession of the defendants. Defendants case koro, apostrophe is there. Apostrophe ta pore. Defendants case throughout is that the documents which are now sought to be disclosed as additional documents, comma, were all along in the possession and custody of the defendants. Had those documents been so important to the defendant, the defendants should have exercised its due diligence on those and could have disclosed them with the written statement, which is a mandatory statutory provision under the law after the promulgation of the CC Act. A mandatory declaration is also required to be made by the defendants in its while filing written statement. If some documents are not disclosed with the written statement, whether they are under the custody and possession of the defendants. The declaration made in the written statement also does not show that these additional documents, which are sought to be relied upon now, were not within the custody and possession of the defendants. Question. Paragraph. Referring to the statements made in the application filed by the defendants, Mr. Dasgupta submits that no sufficient cause has been made out so that this court can exercise its discretion and grant leave to the defendants to disclose these additional documents. In support, Mr. Dasgupta has placed reliance upon a decision of the Honorable Delhi High Court, In support, in support, Mr. Dasgupta placed his reliance upon a decision of a coordinate bench of Delhi High Court in the matter of লেখো এটা reported at 2022 online SCC online লেখো এইটা ভার্সেস এইটা in the matter of করে আমি যেভাবে লিখি আমার যেন আর বলতে না কারেকশন করতে না হয় ঠিক আছে ইটালিক্স বোল্ড বুঝতে পেরেছো ইটালিক্স বোল্ড যেভাবে আমি লিখি in the matter of such and such. First. What else?
No, my lord.
Any further? Any submissions that
No.
I have left?
No, my lord.
Okay. In the light of the above, learned counsel for the plaintiff prays for dismissal of this application. Paragraph. For decision. After considering the rival contentions of the parties and on perusal of the materials on record, it appears to this court that the guiding legal principle necessary for adjudication of this application, of the instant application, are sub-rules 9 and 10 to amended Order 8, Rule 1 of CPC, those are quoted below. Sub-rule 9 and 10 quote করবে Order 8, Rule 1 থেকে। এই দেখো ওখানে পাবে না এই রেগুলার পাবে না 9 10 এখানে পাবে 9 10 এখানে পাবে আর এই বইটা দিতে পারবো না আমি হ্যাঁ দারুণ ব্যাপার এটা তো ভালো বলেছে ঠিক কি বললাম কোটেড বিলো paragraph. On perusal of the averments made in the application, it appears to this court that most of such additional most of the weighbridge slips, sum of which, sorry, काटो, देखो. The defendants principally want to disclose certain weighbridge slips, right, madam? You assist me. Weighbridge slips
and or kata slips. They are referred to as weighbridge slips as well as
and
kata
or
slips.
the other connected slips. Full stop. The case made out in the application is that most of the weighbridge slips and or kata slips which were being relied on by the defendants had been already disclosed by the plaintiff and the defendants and are available in the suit record. It has, however, has come to the notice of the defendants that some of such invoices disclosed by the plaintiff
as well as by the
by the parties did not have the weighbridge slips and or kata slips appended to them. The concerned junior engineer of the defendants, who was entrusted to look after the legal cases of the defendants, including the instant suit, had left the employment with the defendants on or about November 30, 2024. And as such, the documents could not be looked upon while preparing the disclosure of documents on behalf of the defendants. Full stop. When the defendant's witness personally dealt with the matter, after searching the records and after going through it, these additional documents are found to be there in record but not disclosed before the court, but not disclosed in the suit record. First paragraph. The statements in the application have been denied by the plaintiff in its affidavit in opposition. First. On a meaningful reading, paragraph, on a meaningful reading of sub-rule 9 and 10 to rule 1 of order Roman 11 of CPC, it appears to this court that depending upon the fact situation, if the court is satisfied with the explanations offered before the court, that the non-disclosure of the documents are not an act of suppression or deliberate suppression or mala fide, but owing to a bona fide mistake, then upon the defendant establishing reasonable cause for non-disclosure of those documents, comma, the court has ample authority and jurisdiction to grant leave to the defendants for such additional disclosure subsequently. The sub-rules also does not specify beyond what stage of hearing of the suit such disclosure, additional disclosure, such subsequent disclosures are not permitted. On a meaningful and harmonious reading of the provisions, this court is of the considered view that there is no absolute bar on the part of the defendant for not disclosing the additional documents, not disclosing the relevant documents subsequently, but, but of course, subject to the satisfaction of the court and upon leave being granted by the court in this regard. First. Right to defend a claim by a party against whom the claim is lodged is a vested right. Which is recognized not only under the statute, both substantive and procedural, but also which are recognized by law, both substantive and procedural. First. To defend a claim, the party can avail of, the defending party can avail of all the procedures established by law. First. This is also in conformity with the elementary principle of natural justice. Therefore, unless the explanations offered by the defendant is totally illusory. And moonshine. Totally illusory, moonshine, and thoroughly contrary to records. The explanations can be accepted by the court as sufficient reasons. Paragraph. In the matter of Sudhir Kumar Supra, which one? Which paragraph you have really? 10.4.
9.6 I relied on, that my lord has
That's
the
all right.
power. And other than that, my lord, here, my lord, I relied on 10.2, 10.3, 10.4. My lord, Sudhir Kumar said that the court on reasonable cause can allow, but here voluminous documents were being disclosed, so it did not allow. In Sugandhi, my lord, where documents could not be traced, was accepted as a good cause. Sudhir Kumar does not say...
In the matter of Sudhir Kumar Supra, the Honorable Supreme Court had held, upon sufficient cause being shown, the power is available with the court to allow to disclose documents at a subsequent stage. Paragraph. In the matter of Sugandhi dead, Sugandhi Supra, Sugandhi bracketed dead, Supra, which one?
Paragraphs 9 and 10, my lord, I had relied on.
Yes. The Honorable Supreme Court had observed as under. Quote para 9, para 10. এটা করো, কত নম্বর কোট হলো তোমার? 4. ঠিক আছে। Quote 9 and 10. Quote 4, 9 and 10. Post. Para. Paragraph. The test is therefore, as there is no absolute bar for disclosing the documents at subsequent stage, the court has to examine and scrutinize the reasons shown by the applicant. And if the reasons are found to be just and cogent, the court, in exercise of its discretion, can grant the leave for subsequent disclosure instead of depriving the defendants to avail of the procedure of justice, so that it can defend its case, it can get an opportunity to defend its case to the fullest extent. Paragraph. In the matter of Great Gatsby Club of India Supra an application was filed for extension of time to file written statement. Where the principles of Order 11, Rule 1, within bracket 10 of CPC has been discussed. The court there found no sufficient cause being there. The application was not dismissed. Paragraph. The finding of sufficient cause to be just and cogent is the perception of a court. And there is no straitjacket formula to arrive at such a finding. The perception may vary from court to court. Paragraph. In view of the foregoing reasons and discussions, this court is of the firm and considered view that the causes shown by the defendants in its application are found to be just and cogent, and hence the defendants are allowed to disclose the documents positively within 2 weeks from date by following the due procedure of law. They shall be entitled to take inspection and whatever, insofar as the provisions for taking inspection and discovery of documents are concerned. The defendants shall be at liberty to do so. The plaintiff shall be at liberty to do so in accordance with law. And then the documents, after being filed, shall be taken on record as part of the suit record by the department. Full stop. The application is allowed, paragraph, subject to payment of cost of rupees 30,000 to be paid by the defendants in favor of the plaintiff. Plaintiff single?
Yes, my lord. My lord.
Sole plaintiff.
Sole plaintiff.
Sole plaintiff.
In favor of the plaintiff. Which shall be the condition precedent for submission of additional documents. That's all.
My lord, only one thing.
Accordingly, the application IAGA com
Mandate of the learned commissioner was appointed to.
Huh?
The mandate of the learned commissioner was taking evidence, my lord, expired on 3rd November. My lord was pleased to observe that my lord will be extending his mandate side by side with disposal of this application.
But for that, since it has expired, you have to come up with an application.
My lord, subject to correction, my lord, I had mentioned before it had expired, my lord, on 3rd November.
Come up with one-page application.
My lord, I'll do that.
Come up with a one-page application. I don't know.
File a joint application.
কি বললাম? Had it not been expired, even today is the last day, I would have done it here and now. কি বললাম? কত নম্বর IAGA কম?
4.
4 of
2025.
2025. এইটা bold হবে, IAGA কম 4 of 2025. Stance-টা normal, allowed bold. Comma on the above terms.
It be my lord's pleasure to record that the parties have said they will come up with a joint application for extension of mandate of the commissioner.
You come up, whoever will come. That's
My lord. And a ছোট্ট application file করুন।
হ্যাঁ করে নাও। 9-10 ছবি তুলে নাও। চলো নেক্সট।
You should be happy. Praising.
এগুলো সব ওকে দিয়ে দাও, কারণ এগুলো তো স্টিকার মারা আছে। শোনো, এইটা জাস্ট এমনি না, আমার ওইখানে দিয়ে দাও।
Lordship, I am for the plaintiff. Plaintiff is represented by my senior Shaunak Sengupta. Due to medical emergency, he went to Delhi.
ওয়েট এই দুটো স্টেপল করে ওই ফাইলে দিয়ে দাও, কিছু ফাইল করতে হবে না, এটা ফেলে দেবো আমি, ওই কারেকশনটা হয়ে গেল, যাতে একসঙ্গে থাকে। ওই জাজমেন্ট গুলো যেগুলো দেখিয়েছি না, শোনো না, জাজমেন্ট গুলো যে ফাইলটায় আছে সাদা, ওইখানে গেঁথে রেখে দাও, ফেলে দেবো আমি। ইয়েস
For the plaintiff, plaintiff is represented by my
take the microphone.
Plaintiff is represented by my senior Shaunak Sengupta. Due to medical emergency, he went to Delhi. So kindly keep the matter next week. He will be surely come.
What happened?
So that I don't know. Only instruction has been given.
Plaintiff number? Sorry, serial number 3.
3.
On the prayer of Mr.
Shaunak Sengupta. My name is Shoikat Mollik.
Shoikat Mollik, learned advocate appearing for the
Plaintiff.
The matter shall appear under the heading for orders. দাঁড়াও শেষ হয়নি তো, ডেট ফিট গুলো বলবো তো। অন, হ্যাঁ ঠিক আছে, on December 18, 2025, comma, as the learned arguing counsel Mr. Shaunak Sengupta is out of station due to some medical emergency. Paragraph, none appears for the defendants. Chalo, next.
Oblige, madam.
My application appearing for the defendant.
I was submitting.
My lord may be pleased to recall that on the last occasion, Mr. Dasgupta substantially made the submission with regard to my demurrer application. Now, if your lordship kindly permit me, only for the sake of repetition, only a few.
Well, Mr. Dasgupta finished. I was placing a
I only take
judgment.
5 minutes and a few judgments.
That can't. They finished their submissions.
5 minutes is.
Then, my lord, I was trying not to. And I have a supplement.
Then,
I have a supplementary affidavit they have prepared. We wanted to rely on the supplementary affidavit. This is, of course, on the merits. I don't need it for my order 7 to 11.
Not at this stage. After affidavit in opposition, affidavit in reply, because if I have
just
to,
the latest. What is the latest position of our outstanding? It's not required.
I will record, sir. I will record the quantum.
Because this might be necessary if my suit survives. Then in my GA1. Then your lordship will give me leave to file it in the, which is not being heard now. Now GA2 is being.
But the disclosure complete in the suit.
No, suit is.
So it disclose those.
No, I'm for my injunction applications that's pending. Then I'll have to bring this up to date accounts onto record. But I don't need it for this matter. I don't need it at all, because your lordship only needs to see the plain.
Mr. Ghosh.
Yes.
Injunction application You pray for.
That's what I'm saying. I'll pray for supplementary affidavit.
I'm hearing the order 7.
The-
Order
yes.
7.
GA2.
Oh, not the injunction
Not the
application.
injunction application.
So I'm saying instead of of course, in whatever advice they've got prepared the supplementary affidavit. Well, I won't file it. Well, your lordship grants me leave to file it in the.
In that matter, I will
That's
take up.
there, but then it'll get delayed. If of course, if the suit goes, then that doesn't arise.
That's right. So
That's
let
there in the
Affirmed
list.
in GA1.
I know. I'm taking.
No,
this.
he's
I'll
saying
file it.
that. He's saying the same thing. That he has affirmed.
I'll affirm it again and I'll do it in GA2, in GA1.
So keep that for ready for GA1, not here.
That's what I'm saying. That's why I didn't.
That. Yes,
This is a short point, my lord. I was already submitting. I don't know if my learned friend wants to cite some
Let me hear him
cases.
for 5 minutes. Let us both hear him for 5 minutes. Then he will reply to his submission also.
Now, if
Yes.
your lordship kindly be pleased to come to page 54 of my application. Well, may I file my affidavit in reply? Already served.
It's not filed.
Yeah, my lord was not pleased to take it up to take it this on record.
Mr.
yesterday.
Dashgupta said he won't file a reply. Your lordship
Sorry,
recall
See,
there
let
was a
us see.
tearing hurry.
Let
them
us see
file.
the last order.
Yeah.
Millard, given that chance to me, Millard, after hearing me, when Mr. Ghosh took time, adjournment on the last day. And order speaks so.
It was there in the order.
I'm not saying.
Very well. Ashun, first. Mr. Saurabh Mukherjee, learned advocate, appearing with Mr. Nirmalo Dasgupta, learned advocate for the
defendant bank.
Only one
defendant.
For the defendant bank. Is for file his affidavit in reply pursuant to the leave granted by this court on November 10, 2025. Poster. Affidavit in reply filed today in court is taken on record. Full stop. Copy has been served. Yes. Yes. Yes.
Now, if your lordship kindly be pleased to come to page 54 of my application.
Page 54.
Yes. The reliefs claimed in the.
Wait. Yes.
The reliefs claimed in the plaint. A decree of declaration that the acceptance of consideration by the defendant bank against the enhanced offer of OTS proposed by the plaintiff has resulted into a concluded contract.
Yes.
B. A decree of specific performance of contract in respect of the concluded contract between the plaintiff and the defendant bank, thereby directing the defendant to accept the remainder amount of rupees 54 crores within such and such date in lieu of full and final discharge of all the liabilities of the plaintiff company against the defendant bank.
এই এটা রাখো তো সাবধান ঠিক তেরি কি হলো না গুলিয়ে গেছে Yes.
My lord may be pleased to recall that their entire case is that they offered an OTS on the basis of my assurance, and since I have accepted the token amount,
they are trying to specifically enforce that OTS contract.
Yes. And
allegedly OTS contract.
Allegedly OTS contract. Now kindly see claim C and claim D. A decree of permanent injunction restraining the defendant bank from taking any coercive steps.
Yes, please it.
Decree of permanent injunction restraining the defendant bank from taking any coercive step against the plaintiff company which frustrates the concluded contract of OTS between the plaintiff and the defendant.
Only sole defendant is here.
Yes. And D, decree for delivery up and cancellation of the letters of the plaintiff dated 5th February 2025, 18th February 2025, and defendant's letter, 3 letters, 21st January, 13th February, and 19th February 2025. Now, My lord is aware of, and it has also been submitted by Mr. Dasgupta, that section 34 of the Securitization Act. What it is not at all in dispute, loan taken, default.
Just show me the letter.
I'll come to that. My lord, only two sentences, then I'll come to those letters. My lord, these are not at all in dispute, loan taken, defaulted. They applied for OTS on numerous occasions. Earlier, OTS were sanctioned. They are also defaulted. From 2022, bank has categorically recorded at least on by 10 communication, if not more, that no OTS is in force. They made a request on 31st December 2024 that we said you submit your proposal, it will be considered. They say that on the basis of our alleged advice, they deposited 1 more crore. So I am bound by their letter. I have already accepted it. Now, my lord is aware of, and it has been submitted by Mr. Dasgupta, section 34. What the bank has already done, initiated SURFACE proceeding that is pending. No challenge to that till date. In DRT,
45 days expired.
Long back.
When the 13-2 notice?
2017.
Come on, give me the date.
My lord, 13th October 2017.
13th
October 13, my lord.
2017, 13-2.
13-2. Property is lying.
1 second.
I'm sorry, my lord.
Should find.
My lord,
Plaint file.
My lord, not in DRT, my lord, original application.
This plaint file.
This plaint file.
6th of May.
6th May 2025.
Very well. Plaint filed in on 6th May 2025. Notice under section. No section 17, no 13.3a.
No. 13.3a was there. We have replied.
You have replied. 13.3a when?
My lord, 20th November 2017.
Objection under 13.3a.
Yes.
Disposed of when?
My lord, 27th November 2017.
Disposal by bank.
Yes, my lord.
Page.
My lord, it is in GA1 but not in GA2.
All right, okay. You tell me 13.2 which page?
Well, 13.2, page 63.
It must be in your application
Yes, yes.
because you have annexed the entire plaint.
Yes, page 63.
13.3a.
Well, 13.3a and the disposal, those are not in. They are in GA2.
Where is GA1?
My lord, page 69, affidavit in opposition to GA1.
1 second. Page 69, AO2, GA1.
Yes.
And the disposal, 27th of November.
Page 73, affidavit in opposition to GA1.
Very well. Yes, then.
So, my
No
lord,
section 17 file.
no section 17. Possession of the secured property is lying with them.
Yes.
Bank made attempts to sell those property by public auction, at least on around 10 to 15 occasions. No bid has been received. They claimed they were trying to get some purchaser. No purchaser had made any formal communication through them as well.
Last of such when taken? Last of such attempt?
I'll give the exact date, my lord. In 2020, in 2021. In 2021.
Last sale, attempt for sale.
Last attempt for sale by public auction.
21.
sale in 2000.
21 by public auction.
That should be. Acha. 13-4 notice served.
All right, I tell your lordship, 6th February 2021.
13-4 notice served.
No.
Has to be.
My lord, I'm sorry. 13-4 with regard to intimation of possession of 14th February.
6th of February.
6th February 2021, last of the sale notices.
ঠিক আছে. And 13-4.
My lord, 14th February 2018.
14th February
2018. 18.
13-4.
Yes, my lord.
Possession notice.
Possession notice.
Acha, where do I get it?
My lord, I'm sorry, my lord, it is not on record.
Acha. Last sale notice is on record.
No.
Acha. All right. Proceed.
Now, my lord, besides surface action, we have initiated or we have filed original application.
When filed?
My lord, way was filed 2019, 5th March 2019.
Right. Way number?
Way 182 of 2019. DRT. Before the Debts Recovery Tribunal 1.
Next.
And Section 7 proceeding has been filed in March 2024.
Section 7 for what?
My lord, before the learned NCLT. I am the financial creditor.
Section 7 under IBC.
Under IBC.
On
filing a date.
In the year?
In March 2024. What is supplementary paper here?
Just a correction, with leave of Mr. Mukherjee. The first section 7 was filed in 2020. First section 7.
Why first and last?
Because before OTS, we withdrew then, because they gave a settlement proposal. We withdrew that, in view of that proposal. Then we went back to the NCLT when they failed. Then afresh it was filed before the NCLT again in 2024.
Okay. Since the settlement fails, again it was
Yes.
Next.
So, my lord, if why I placed the claims the relief sought for in the complaint, if today they get those reliefs, 1, my surface action, 2, original application in the DRT, 3, Section 7 application before the learned NCLT gets frustrated. Now, whether under the present position of the law of the land, whether my lord will be pleased to allow the final relief, and if the final reliefs cannot be allowed, then I am reserving those submissions for GA1. Now, your lordship is well aware of Section 34.
Yes, 34 is different.
Of the Surface Act.
How 34 is attracted? In the light of the reliefs made in the plaint.
Yes, my lord. Kindly see claim C once again.
Yes.
They are asking for a order of or decree of permanent injunction upon me, restraining me from taking any coercive step which will definitely frustrate my surface action.
You tell me, Mr. Mukherjee, what injunction has been passed? Any injunction has been passed as of now?
Not yet.
It's lying as direction with affidavits.
Yes.
The injunction has to be hard.
My lord, I am on Order 7, Rule 11.
That's a different issue. I am asking, no injunction has been.
They did not press for ad interim.
So it is merely lying with the affidavit directions. Okay, now you place your Order 7.
Now, as soon as my learned friend, had it been a simpliciter declaration, I would not have made this submission before your lordship. But as soon as my learned senior friend has claimed this relief, this is the jurisdiction of this honorable court, my lord, with my deepest respect, cannot be invoked at all, and it is barred. If your lordship kindly be pleased to allow me.
Kindly see, read prayer C.
A decree of permanent injunction restraining bank from taking any coercive step. Well, pausing here for a moment, coercive step will include my invocation or my right of invocation with regard to the mortgage property, my right.
What you are saying, in effect, surfacey.
In effect, surfacey. And as soon as I am restrained to invoke my right or to pursue it, the existing proceeding or existing surfacey proceeding, it is hit by section 34.
But the question is, last sale notice was published in 21.
Yes, my lord.
The plaintiff filed in 25. Right. You have not yet received any purchaser. Let us accept the facts.
Yes.
You have not yet received any purchaser. All right. Then,
my lord, now to meet my lord's query, if I have correctly understood what is falling from your lordship, I did not receive any purchaser at 39 crore. Does not mean that
tomorrow you will not get.
Tomorrow I will not get a purchaser at 10 crore. I have not yet, being a nationalized bank, I have not yet tried to bring the price of the property that low.
Then,
so my lord, with regard to surfacey, my lord, this is my submission. If your lordship,
now you have to submit on the judgment.
Now,
I haven't cited officially.
You have cited last occasion?
I haven't.
Oh, you have completed. We have not completed.
Nothing I've done.
They have snatched.
Yes, your lordship has allowed him to snatch.
Snatch it. Yes.
Now, if your lordship kindly allow me.
What is this?
My lord, a judgment passed in 2018, volume 8 SCC on
2018.
2018
volume
8 SCC.
Yes.
Page 120.
120. Yes.
My lord, only one paragraph I will show. Paragraph 8, my lord, at page 123. After having considered the rival submissions of the parties, we have no hesitation in acceding to the argument urged on behalf of the bank that the mandate of Section 13 and in particular Section 34 of the Surfacey Act clearly bars filing of a civil suit.
Read on.
For no civil court can exercise jurisdiction to entertain any suit or proceeding in respect of any matter which a DRT or DRAT is empowered by or under this act to determine, and no injunction can be granted by any court or authority in respect of
Agreed. Show me the prayers in the plaint.
My lord,
from the judgment. Not the plaint filed by Mr. Ghosh's client. From the judgment.
My lord, this judgment.
What was the plaint in the judgment?
My lord, this judgment emanated from a different proceeding. Now, DRT, DRAT, and then writ petition. My lord, may be pleased to find.
Come on, next.
Now, coming back to the facts of the case, the latest, now I'll place quickly
Hey,
before your
Yes, next.
Now I'll quickly place a few letters. Those are the subject matter of the dispute.
I'm not going to look at it at Water 7 Rule 11 stage.
No, my lord was pleased to direct me just now to place those 5 letters with regard to which the reliefs have been claimed in prayer D.
I'm not going to look at it. I accept your contention. You have to sustain your Order 7 Rule 11 plea on the basis of the plaint.
Absolutely.
The classical theory.
Absolutely.
So accept, sustain your application.
Now, March 2024, I have filed a Section 7 application before the learned NCLT. Pleadings were completed. It took a longish time. Then this OTS situation had come.
OTS, according to you, OTS failed?
OTS
and Section 7 is pending.
I say that their proposal was not at all an OTS.
Whatever, sir, OTS failed. Matter ends.
Very fine.
You have rejected.
They say that I have to go by that OTS and it is binding on me. They filed an application. They moved this honorable court by filing a suit CS 23 earlier. That time, the honorable coordinate bench was pleased to observe that you should go for mediation, and suit was withdrawn. Mediation has failed. It was a non-starter. That time, they filed an application for stay before the learned NCLT that has been dismissed. Now, after filing of this,
Mr. Shauram Mukherjee, I accept 17 is pending.
Yes.
Section 7 is pending.
Now,
Section 7 pending.
Yes.
Section 9 under DRT Act pending.
Yes.
Surfacey notices are there.
Yes.
Right?
Absolutely.
I accept.
Now, your lordship is aware of Section 41 of the Specific Relief Act.
No injunction to restrain a proceeding.
Absolutely.
Yes. How does it matter?
And Section 63 of the Insolvency and Bankruptcy Code.
Exclusive
jurisdiction is lying with the learned NCLT.
I accept.
So in the light of this, no relief can be obtained by my learned senior friend from your lordship, which will frustrate either of those 3 proceedings.
Correct.
Now, 2 judgments. One Minal Agarwal 2023.
What is the proposition?
This is the proposition that I just now submitted.
No. What?
That NCLT procedure, that one, if OTS cannot be thrust on me, it's a matter of settlement. Any settlement cannot be imposed on a party. A party cannot, no order can be passed or to accept a settlement.
Show me. Unless it acquires the character of a decree.
Yes. Paragraph 2023, volume 2 SCC. Page 805.
Come on, give me the citation.
2023.
Yes.
Volume 2 SCC.
Yes.
805.
805.
805.
Yes. Let's see.
Well, paragraph 8 at page 813.
Paragraph 8.
Yes. Therefore, as per
Mr. Mukherjee, if you can just read paragraph 5 onward. 5.
Very well, my lord. If you
5.1.
if I may start from 5.1. It is submitted that
Yes, paragraph.
Paragraph 5.1 to 5.1 and 5.2 at page 810.
Yes, sir. Show me.
Yes, my lord. It is submitted that under the OTS scheme, a loanee is required to deposit at least 25% of the total amount along with the application.
Acha,
How-
1 minute. 5. Yes. 5. First place 5.
The present appeal is vehemently opposed by Mr. Such and Such, learned advocate appearing on behalf of the respondent number 1, the original writ petitioner. It is submitted that in the present case, as it was found, that though the original writ petitioner is ready and willing to deposit the entire amount under the OTS scheme, and though she is eligible for grant of the benefit under OTS scheme, her application for grant of benefit under OTS scheme was rejected, which is found to be arbitrary and against the principle of natural justice. The High Court has rightly set aside the decision rejecting the application of the original writ petitioner for grant of the benefit under OTS scheme. It is submitted that under the OTS scheme, a loanee is required to deposit at least 25% of the total amount along with the application. However, the original writ petitioner deposited more than 50% of the amount to be paid before her application for grant of benefit under the OTS is considered. It is submitted that the check for the said amount came to be accepted by the bank and even the same was credited in the NPA account, thereby showing that her request for OTS had been accepted. It is submitted that thereafter to reject the application for grant of benefit under OTS is mala fide and arbitrary, and therefore the High Court has rightly issued writ of mandamus and has rightly directed the bank to positively consider her case for grant of benefit under the OTS scheme. 5.2, my lord. It is further submitted that as such the original...
I'm coming within 5 minutes, Mr. Ghosh. I'm coming, Mr. Ghosh, within 5 minutes. Madhur ko lago na? Coming, 5. Yes.
I was placing paragraph 8 before your lordship.
Yes.
Therefore,
Paragraph 8. Yes.
therefore, as per the guidelines issued, the grant of benefit of OTS scheme cannot be paid as a matter of right, and the same is subject to fulfilling the eligibility criteria mentioned in the scheme. The defaulters who are ineligible under the OTS scheme are mentioned in clause 2 reproduced here and above. A willful defaulter in repayment of loan and a person who has not paid even a single installment after taking the loan and will not be able to pay the loan will be considered in the category of defaulter and shall not be eligible for the grant of benefit of OTS scheme. Similarly, a person whose account is declared NPA shall also not be eligible. As per the guidelines, the bank is required to constitute a settlement advisory committee for the purpose of examining the application received, and thereafter the said committee has to take a decision after considering whether a defaulter is entitled to the benefit of OTS or not, after considering the eligibility as per the OTS scheme. While making recommendations, the Settlement Advisory Committee has to consider whether efforts have been made to recover the loan amount and possibility of recovery has been minimized, meaning thereby if there is possibility of recovery of amount either by initiating appropriate proceedings or by auctioning the property mortgaged and or properties given in the security either by the borrower and or by the guarantor, the application submitted by the borrower for grant of benefit under OTS scheme can be rejected. Now, what happened in this case in paragraph 9. Now, if your lordship kindly turns to paragraph 11 and 12. While passing the impugned judgment and order, the High Court, in response to the submission on behalf of the bank that there are all possibilities of recovery of the loan amount and efforts are being made to recover the amount by initiating proceedings under the SARFAESI Act, and that the properties mortgaged can be auctioned, has observed that the proceedings under the SARFAESI Act have remained pending for 7 years and the bank has been unable to recover its dues, and therefore the hope of recovery is illusory. This conclusion is not supported by any material on record. Merely because the proceedings under the SARFAESI Act have remained pending for 7 years, the bank cannot be held responsible for the same. No fault of the bank can be found. What is required to be considered is a conscious decision by the bank that the bank will be able to recover the entire loan amount by auctioning the mortgage property, and a due application of mind by the bank that there are all possibilities to recover the entire loan amount instead of granting the benefit under the OTS scheme and to recover a lesser amount. It is ultimately for the bank to take a conscious decision in its own interest and to secure or recover the outstanding debt. No bank can be compelled to accept a lesser amount under the OTS scheme despite the fact that the bank is able to recover the entire loan amount by auctioning the secured property or mortgaged property. When the loan is disbursed by the bank and the outstanding amount is due and payable to the bank, it will always take a conscious decision in the interest of the bank and in its commercial wisdom. 12, my lord, the last paragraph, I'll cite from this judgment. Even otherwise, as observed herein above, no borrower can, as a matter of right, pray for grant of benefit of OTS scheme. In a given case, it may happen that a person would borrow a huge amount, for example, rupees 100 crores. After availing the loan, he may deliberately not pay any amount towards the installments, though able to make the payment. He would wait for the OTS scheme and then pray for grant of benefit under the OTS scheme, under which always a lesser amount than the amount due and payable under the loan account will have to be paid. These despite there being all possibilities for recovery of the entire loan amount which can be realized by selling the mortgaged or secured properties. If it is held that the borrower can still, as a matter of right, pay for the benefit under OTS, in that case it would be giving a premium to a dishonest borrower who, despite that the fact that he is able to make payment and the fact that the bank is able to recover the entire loan amount even by selling the mortgage properties either from the borrower and or guarantor. This is because under the OTA scheme, a debtor has to pay a lesser amount than the actual amount due and payable under the loan account. Such cannot be the intention of the bank while offering OTA scheme, and that cannot be the purpose of the scheme, which may encourage such a dishonesty.
Next paragraph.
If a prayer is entertained on the part of the defaulting unit or person to compel or direct the financial corporation bank to enter into a one-time settlement on the terms proposed by it or him, then every defaulting unit or person which or who is capable of paying its dues as per the terms of the agreement entered into by it would like to get one-time settlement in its favor, who would not like to get his liability reduced and pay lesser amount than the amount he or she is liable to pay under the loan account. In the present case, it is noted that the original writ petitioner and her husband are making the repayments regularly in two other loan accounts, and those accounts are regularized, meaning thereby they have the capacity to make payment even with respect to the present loan account, and despite the said fact, not a single amount or installment has been paid in the present loan account for which the original petitioner is praying for benefit under the OTA scheme. Then, my lord, paragraph 14, two more paragraphs are there, paragraph 14 and 15. The sum and substance of the aforesaid discussion would be that no writ of mandamus can be issued by the High Court in exercise of the power under Article 226, directing a financial institution to grant benefit of OTS to a borrower. The grant of benefit under the OTS is always subject to the eligibility criteria mentioned under the OTS scheme and the guidelines issued from time to time. If the bank or financial institution is of the opinion that the loanee has the capacity to make the payment and that the bank or financial institution is able to recover the entire loan amount even by auctioning the mortgage property or secured property either from the loanee or guarantor, the bank would be justified in refusing to grant benefit under the OTA scheme. Ultimately, such a decision should be left to the commercial wisdom of the bank whose amount is involved, and it is always be presumed that the financial institute or bank shall take a prudent decision whether to grant the benefit or not under the OTA scheme, having regard to the public interest involved and having regard to the factors which are narrated herein above. Now, in view of the aforesaid discussion and the reasons stated here and above, we are of the firm opinion that the High Court in the present case has materially erred and has exceeded its jurisdiction in issuing.
You tell me when the kindly come to the prayer of the suit.
My lord. Page 54 of my application.
Prayer page?
Page 54 of my application.
Show me the OTS related documents.
Page 110, 110.
What is that?
My lord, in this respect, the first communication that was initiated.
Page
110. Other application 110. J2. My lord, I'm sorry. Page 141. I'm sorry. Page 141. Thank you. Well, it's a little longish letter. I'll place only the relevant portion. This has reference to the borrower company is writing. This has reference to the video conference the undersigned had with your general manager, recovery HO, and other senior officials on 20th December.
Have you rejected this letter?
Yes, it has been rejected, saying that it was not at all an OTS.
Show me the document.
Kindly come to page 148. I will check for it.
Second one.
Hard copy to check for it. Page 148.
148.
Well, second paragraph.
Wait. The 1110 contains 56 crore.
Yes, my lord.
Yes?
Yes.
Yes.
So it has been rejected. They say.
Show me it was for 56 crores from 110.
My lord, kindly come to page 148. I'm sorry, 141.
Show me from 110 it was.
My lord, page 141, numerical 1. After.
Wait. Rejection is
148.
Page you have just
148.
dated 148.
Yes, dated 21st January 2025.
January
2025.
1 second, sir. And show me from 110 it was for 56 crore.
No, it was not 110, 141.
141.
Yes.
What is that? Then what was 110?
Well, I stated the page number incorrectly. It should be 141.
It should be 141. Page
141.
কোথায় বলেছে 56
But
crore?
after 3 subparagraphs, there is a numerical 1.
Yes.
The OTS offer stands enhanced by 1 crore to the total OTS offer now comes to rupees 56 crores.
Yes.
And my lord, another letter is very important. After I issued this letter dated 21st January, their first communication, 5th February.
Yes, show me.
My lord,
Which
it is
page?
at page 151, volume 2.
Good. 151.
Yes. The borrower is writing,
Yes, 151,
Yes.
sir.
The borrower is writing, we acknowledge receipt of your above mentioned letter and
Letter dated
5th February 2025. My lord, right hand side.
above mentioned letter.
My lord, above mentioned letter, the number is there under the reference. Your letter.
That tallies with your letter.
That, my lord, I'll just এক second. Judge Sahib যেটা জানতে চাইছি উত্তর তো। Yes, AX9 loan, Shenbo Engineering. Yes, tallies.
Where is the reference? Your letter is FN
148. 148.
What is that?
That letter, 21st January 2025. My letter.
Yes. AX9 is the reference number.
148. Letter,
What
annexure
does it
R.
say?
148, my lord, I placed that I rejected.
151,
151.
148 you have rejected.
I have rejected. Now the immediate reaction. We acknowledge receipt of your above mentioned letter and noted the contents therein. Subsequently, we had detailed discussion in the present matter with your good self at your office on the date on the basis of the referred letter. In terms of our discussion, we lay down the following facts along with our revised proposal for your kind consideration and approval. We understand from your above mentioned letter that the proposal is not in compliance with the bank's policy, which requires 10% of the OTS amount as upfront payment or 25% in no-lien account. Quarterly repayment schedule needs to be
Then
set.
what happened?
So, my lord,
in this regard.
So today,
come on, read.
In this regard, we submit as under our OTS offer for 56 crores, 10% of which comes to 5.6 crores, out of which we already paid 2 crores and the balance remains rupees 3.6 crores. We undertake to stretch ourselves fully to raise funds from all possible sources, including friends and relatives, and make good the balance amount of rupees 3.6 crores by first week of March 2025. Which shall be in compliance with the bank's policy.
So what happened? Have you dealt with this?
No.
You have not dealt with it.
No, I have dealt with it, but what they said that they will come with and meet
money
and meet the bank's
but
policy.
They have not come up.
They did not come up with money or did not meet the bank's policy. So my rejection
stands. So you say that this letter was not replied?
This letter
because they did.
This letter was replied.
153.
153. 13th February, page 2025. February 2025.
Yes.
We refer to your aforesaid mentioned letter and our various earlier communication in the caption matter. Vide our letter dated 21st January, we have already informed you that the OTS proposal of 56 crores is not acceptable to the bank for the reasons stated in the letter. Vide the said letter, you have informed that balance 10% of the upfront amount, that is rupees 3.6 crores, will be paid by first week of March 2025. It has been already informed to you that upfront amount is mandatory and prerequisite for submission of OTS proposal, which you have failed to submit. It has been informed by your letter dated February 2025 that selling of mortgage land is in advanced stage and necessary documents from the competent authority also obtained, and you have proposed to repay 50.40 by December 2025 from sale of the land and surplus generated from the existing works. Then, my lord, earlier communication that where they have failed, those have been discussed.
Sure.
Now, next page.
Yes, I've read it. Yes, what else?
So, my lord, on fact, there is no OTS before your no OTS is in force. What they are saying that there is an OTS, I have accepted it. So I am bound by that. That submission cannot is not at all good and absolutely incorrect. And on law, no relief can be granted as obtained in this suit. No relief can ever be granted to stall my Section 7 proceeding or
to stall your realization process.
Right.
You might have 25 proceedings, realization process.
And my lord, Minal Agarwal, my lord, I have just placed formally, my lord, I am citing another judgment which has followed Minal Agarwal, 2023 volume 2.
2023
volume 2, I have just now cited before your lordship. Now, another judgment, 2023 volume 1.
2023 volume 1 SCC.
SCC, page 540.
Yes. Paragraph?
My lord, here paragraph 19 to 23.
90?
19.
19.
বলবি
নাও বাবা একেবারে লাগিয়ে দাও
ঠিক আছে But since it has followed the earlier one,
yes, show me the relevant part.
Paragraph 19. As rightly submitted by the learned
wait.
I'm sorry, my lord. Bombay High Court.
Paragraph
19, 19.
The present case.
Paragraph 19. In the present case, in the sanction letter dated 2007.
Wait. Yes, in the present case.
In the present case, in the sanction letter dated 21st November 2017, it was specifically provided that the entire payment to be made by May 2018. The schedule to make the payment under the installments was also mentioned. It is an admitted position that the borrower did not make the payment due and payable under the sanctioned OTS scheme on or before the date mentioned in the sanction letter. The prayer of the borrower for extension of 9 months came to be rejected as far as back in May 2018. And the borrower was directed to make payment of rupees 2.5 crore by May 2018. The borrower failed to make the payment. At this stage, it is required to be noted that during pendency of the writ petition, there was as many as 3 different OTS floated by the bank, and the bank offered the respondent borrower to settle the outstanding payment under OTS scheme. However, the borrower did not opt for any of the scheme. By the impugned judgment and order, the High Court has granted further 6 weeks' time from March 2022, which would be beyond even the time paid by the borrower in the year 2018. As observed above, earlier period of 8 to 9 months was sought in the year 2018, and by the impugned judgment and order, the borrower has got time up to May 2022. Even otherwise, as rightly submitted on behalf of the bank, directing the bank to reschedule the payment under the OTS would tantamount to modification of the contract, which can be done by mutual consent under Section 62 of the Contract Act. By the impugned judgment and order, rescheduling the payment under the OTS scheme and granting extension of time would tantamount to rewriting the contract, which is not permissible while exercising power under Article 226 of the Constitution. It is required to be noted that the that under the OTS scheme, which was originally sanctioned in the year 2017, the borrower was required to pay rupees 10.50 crore against the outstanding of rupees 13.99 crore. Therefore, under the original sanctioned OTS scheme, the borrower...
Here it was a case of sanctioned OTS.
Yes.
Not required. All right. You
And-
completed?
My lord, paragraph 15, my lord, also kindly take formally note there where it has followed Minal Agarwal.
Yes, I've seen the three sub-paragraphs.
Yes.
Three sub-paragraphs.
Absolutely.
Roman 1, Roman 2, Roman 3.
Absolutely, madam.
I've seen that.
My lord, slightly on this, on the same issue, there is
Multiply, don't multiply. Don't multiply on the same issue. These are your submissions?
These are my submissions.
All right.
Doesn't stop.
Keep বুঝতে পারছি না।
He's having
You have done? You have done?
Yes, yes.
Thank you, sir.
Formally, Mr. Mukherjee, if you can just formally cite that and put it on record, the Bombay High Court. And the citation দিয়ে দাও, just put it on record.
No.
Recent, most recent.
That is not the way. That's not the practice of this code. Either you have to cite it formally.
Very well.
Cite it formally, I don't mind.
Formally, তাহলে দেখিয়ে দাও।
If it is a repeated citation on the same principle, then the court might take exception in its judgment. Don't multiply the judgment on the same point.
Very well, my lord. Mr. Dasgupta
Very
has
well.
been to do research in this matter.
Doesn't matter. Don't multiply. You have shown Supreme Court. What else? Don't multiply by wasting the time.
Very well.
If you have a new judgment on a new proposition, you are absolutely welcome.
Very good. It's a 2025 Bombay judgment that will for that reason only. That's
Yes. Mr. Ghosh.
Only thing, after lunch, I will not be available.
No, sir. Your junior will take care of it.
Because
No, sir. On the last day also, I accommodated. Your junior is competent. He will have to proceed, sir.
I'll try and be. My appeal is going on.
Then again, you come and join. I don't mind thereafter. But
If it's over, I don't know what it's going on since 11 because the item 2 got called at 11:15. So I've left Mr. Mukherjee there. So I will have to face the music there also. If it continues after lunch, might not. I'll come. I'll do this. This is my one judgment, though my time was snatched away as
no
your
problem.
lordship said.
You take as long as you want,
Yes.
but you complete. I don't mind. Take
I'll
as
come
long as you want. That is not an issue. Or this can be done also. Your junior can proceed for the time being.
No, I'll come. Your lordship has said.
You can join after marking there.
The marking is done, but it's Mr. Mukherjee's I have to face. I'm left him in come.
That can be done. No problem.
Okay.
Yes,
If my lord takes GA2, what is
that's the demerit.
Yes. So what I want to say, what is the grounds that are
Yes,
pleaded
yes,
for Order 7, Rule 11?
yes.
If my lord comes to paragraph 11 straight away. Before that is history. The plaintiff has said this, that, etc.
Just 1 second, Mr. Ghosh.
Yes.
GA2, paragraph 11.
Paragraph 11, page 8. It's a fact that SURFACE was initiated in 2017. Then in the Debt Recovery Tribunal, OA was filed in 2019. Then they filed before NCLT. That was withdrawn because there was an OTS. Then we couldn't comply with the first OTS. So immediately on our first breach, they refiled in. So this really reflects on how much faith they have on the DRT system, that they have to go now and get a quicker remedy, as it were, before the NCLT. So first OTS, first they filed before the NCLT. There was a OTS. They withdrew their application, or it was dismissed. Then, my lord, again second time there was a breach. According to them, they filed again before the tribunal, NCLT. Then,
but this OTS arises.
I'm coming to that. That was the first OTS. Then there was
which
breach.
is not this one.
Then there was another OTS. While this matter is pending, this was concluded according to us on 31st of December last year. And they said that it was 55. I'm just giving the background. I'm not, my learned friend has given the page numbers.
You are absolutely free to proceed in your own way.
So, my lord, what happens is the next OTS happens. So it was originally for 55 crores. Then they said, no, you pay 1 more crore and we will consider it. So we put in another crore. So 2 crores we had put in. And that was on 31st of December. They accepted, according to us. I'll show that letter. That document wasn't shown. Thereafter, in January, according to us, they reneged. And they wrote 3 letters which were placed before my lord. And those 3 letters are the subject matter of my suit. I'm wanting cancellation of those 3 letters because it's in violation, or it's contrary to their own agreement, which I'm trying to enforce. So that's the history. Now, page 8. So paragraph 10, I'll just to get some background, I'll place.
Yes.
It is evidently clear and glaring that the plaintiff approached this court by suppressing material facts. What these material facts are, at least in the submissions, no one has said what we have suppressed. And my submission, of course, is nothing. These are all on record. In fact, this petition doesn't have all the facts. It is contended that the averments amount to misrepresentation, and as it does not reveal the real facts behind the scene, and hence the suit deserves to be dismissed summarily on this ground itself, as the plaintiff approached this honorable court with unclean hands. If I may pause here for a moment, Maral. To my best of my recollection, last day or today, this was not pressed. Their ground is there's a bar under the statutory scheme. So this ground was not pressed. They haven't told my lord what are the facts I've disclosed. All these facts are admitted. All the documents my learned friend has placed, they're in the plaint. They're the subject matter of challenge in the plaint. So paragraph 10, I take it, my lord, that I don't need to argue this further, because nothing has been demonstrated that I'm trying to pull wool over the court's eyes or etc. or fast one. Then paragraph 11, this is their case. Section 34 of the Securitization Act, my lord, reads as follows. I'm not placing this. Only thing, as I told my lord, Section 34, Section 18 of the Debt Recovery Act, and Section 63. 63, I think. Say they're identical. The language is identical. But they have gone on 34. And the case that I cited, and I will again cite, clearly says that this is not a bar to filing a civil suit. No civil suit, a court shall have jurisdiction to entertain any suit in respect of any matter which a debt recovery tribunal or appellate tribunal is empowered. Now, is this, if I may pause here for a moment, your lordship has been shown the prayer A and B under no stretch of imagination can be the subject matter of a debt recovery tribunal suit, independently to be filed by a private party. Only the financial institute can file a suit there. And no injunction shall be granted by any court in respect of any action taken in pursuance to that. But that is a separate matter. Injunction under Specific Relief Act also, I can't stop someone from pursuing in a court of law. But I can stop him from taking coercive measures and locking up my assets, disallowing me from using the. If he has got an order of court, well and good. But other coercive measures, I can definitely stop someone from barging into my house and taking the law into his own hands, as it were. So by merely contending or seeking a stay before those tribunals, because my civil suit is pending, doesn't make my civil suit bad in law. And we are on this limited question. My learned friend has really argued the suit. Was there a concluded agreement or not? That is the subject matter of the suit. Now, then 12 is not, now 13, my lord will see. 12 says that they had filed a OA, that's correct. 13. I respectfully submit that the present case has been instituted before this honorable court in the original jurisdiction of the commercial division, where the honorable court may be pleased to adjudicate issues raised therein as civil court. However, it would appear from the aforesaid that the mandate of the law of the land, all in capitals, that in view of the statutory provision of this honorable court, has no jurisdiction to try and entertain this subject matter of the suit, inasmuch it is only the learned debt recovery tribunal which is empowered to adjudicate these issues. So nothing about IBC, though that was already pending before I filed the suit. That is 11 and 12, and then my lord, 14. Now they bring SARFAESI. The defendant bank, being a secured creditor, has taken steps under SARFAESI in order to recover its legitimate dues in respect of the loan facility, etc. And this court has no jurisdiction to try and adjudicate the instant suit, and as such, the bank prays for rejection of plaint. Now, what has not been elucidated before my lord is there is a mortgage. My learned friend has said there were many attempts to sell it, they haven't sold. That money, the 39.5 crores that is secured by that land, is not the subject matter of the OTS that I find. OTS is something to do with the rest of the claim, because that the bank has taken possession of initially. Now it's in our possession because they have failed to sell it. So that 39 crores is not the subject matter. That land is not the subject matter of this suit. So the case they cited.
But the moment 13.2 has been issued, 13.9 operates, and by virtue of a statute, there is an injunction.
Perhaps there is no, it's not his allegation. I'm selling it off. I'm asking the bank to sell it. The bank hasn't managed to sell it for the last 8 years. And that is not the subject matter of the OTS. The OTS is to do, when 95 crores was due.
OTS was on the whole amount.
No, there's a two. I'm not going into the details because that would be arguing the suit. But my understanding is there's a bank guarantee amount of 130 crores and there's a loan amount, etc. for 95 crores. We are concerned with this 95. Out of the 95, we have paid 55 back since the first OTS. Then we failed in our thing, so there was only 55 left, or 55. And then over time, and then when we came to the agreement that we will pay this 55 in 1 year, that 1 year will expire on 31st December this year. We gave our word that we will pay this 55 back, and they agreed. And this was all happening in 2025 also. So then they said, put in a crore. I put in a crore, then they said put in another crore, increase it to 56. It was increased to 56. I'll show that letter. The bank said.
The bank said 56.
No, that letter has not been shown. I'll show it. Last page, my lord, will come to 146, sorry.
But this the bank has refused your 56.
My proposal at 141 was shown. The next letter is 146. Refusal will come to. First acceptance, let it happen. 31st December 2024, page 146. This is in reference to your letter where you have increased the OTS offer from the earlier 55 crores to 56 crores with other modified terms as discussed in the meeting of 20th December at a high-level committee of top executives. we advise you to deposit 1 crore towards the upfront amount as discussed and agreed. You are hereby requested to do the needful and to enable us to proceed further. So this is where they accept and they tell us to put in 1 crore. Then we put in the crore.
This is your document showing acceptance of OTS.
This is the contract. This was the contract.
So this is the sole document on which
might not be sold. There is, of course, so I'm just showing from their own petition that this is there. This wasn't shown to my lord. This is the main thing, that our agreement that we are wanting a declaration that our rights crystallized here once I paid that 1 crore. I changed my position by paying that 1 crore. Then what happens is, after I pay the 1 crore, they say, no, this is an OTS. You have to, according to our policy, you have to put in 20% of the OTS amount. This 20% I had put in when the claim was 95 crores. My first OTS, I put in 20 or 10% or whatever the percentage is, whatever the policy is. I put in that amount. And then this OTS was continuing. I paid off around 55 crores. Then when it failed, the fresh OTS, now the fresh offer was given, and it was, according to us, accepted. So now when they started saying, no,
this was a part of your plaint.
Yes, this is so this is there. And then the next few letters that my learned friend showed my lord, which was at pages 148, then 151. Those are the subject matter of my suit. I have said one is my letter. I was forced to write this letter saying that no, we are agreeing to pay 20. After this letter, there's a letter of ours where we have said that we have put in 1 crore, we'll put in 3.4 more crores. We will put in. That was the one letter. We have said that is one done by coercion. We want that letter to be cancelled, delivered up and cancelled. In reply to that letter, they said that you are not putting in the 20%, you're not putting, we are going to revoke the OTS. That we want, because once if I am right, I get my prayer A declaration that it's a concluded contract, those letters fall also. Because unless they show there's a new agreement. But we are saying those were done by force. So those letters we have taken the precaution of challenging those letters. Those letters cannot be the subject matter of any of these 3 statutory tribunals or processes, as it were. So that being the situation, now I was wanting to bring in a supplementary affidavit. I've put in a further 14 crores this year. And that is lying in a non-lien account. So it's more than that 10% of that, the amount, I have put in this amount. On 12th of November, I have put in another 14 crores. Not the subject matter of my Order 7, Rule 11, no doubt, but I need to say something. I don't want to show that this is a very infamous, whichever one. It's a big engineering company and it's got a lot of projects. In fact, 2 of the awards are pending. The execution of the awards are pending. And it's not a fly-by-night matter organization. That's all I wanted to show, that we have put in our 14 crores also. But that is, in case your lordship is thinking about the equities. But as far as GA2 is concerned, these are all irrelevant. Is it whether these 3 paragraphs, 11, 12, and 14, do they bring out a case that my suit is barred by law? And this 11, what is stated in 12 and 14, as far as the Debt Recovery Tribunal Act and the SURFACE Act are concerned, has been completely interpreted and is done away with by this judgment that I cited. My lord, may I cite that judgment? Then just for completeness, my lord.
No, you absolutely.
No, before coming to just before I leave GA2, my lord will also come to page 11, paragraph 16. They know that the NCLT cannot be stayed and the NCLT cannot have the jurisdiction. So they have not stated in their GA2 that there is a bar under section 63 of that of the Act, IBC. So now your lordship will see what they have said in paragraph 16. It would appear from the conduct of the petitioner in not pressing for ad interim order in GA1 was taken up for hearing, coupled with the fact that showing pendency of the proceeding, the petitioner has filed another application before the NCLT for stay, establishes that the petitioner has been acting in a malafide and surreptitious manner. This is their complaint as far as the NCLT is concerned. And last time, the whole time was tried to tell my lord how this thing can be taken up as a defense in the NCLT and done away with. That's why I've brought a judgment, because like your lordship says, our generation, we skipped the initial part of the IBC. So we've not been doing that. So what is section 7? What do they decide? It's not like a winding up where they will adjudicate my debt. They'll decide whether it should be admitted. It will be sent to the professional. He will decide the rest. They don't adjudicate the debt, as it were. So either they'll see if there's a default. If there's a default, they will admit it. And if there's no default, they will dismiss that application. And so obviously I will try to show that there is no default. This was the agreement, 1 crore I have paid. And now, which is in my supplementary, I'm not bringing it now before my lord. If it continues, then I would pray again. If the matter somehow goes on, then I would pray. Otherwise, as far as Order 7, Rule 11, it's not really necessary. So let us test this proposition. Is there a bar under Section 34 for me filing a civil suit for any of these reliefs? Now, if my lord sees to 2023, Volume 1, page 1. Where's my iPad? I just placed Surface Act, Section 34, I just placed. It's placed.
Quoted.
It's quoted.
Quoted.
Well, Junior has woken up. Now, if my lord comes to, I'll use the paragraph 1. This is 2023, Volume 1, SCC, page 1. Bank of Rajasthan versus VCK. If my lord comes straight to page 8, the first paragraph of the Justice calls judgment. The present reference arises from a question mark over the legal right of the borrower to initiate proceedings before a civil court against the bank or financial institution.
One second. Yes.
The present reference arises from the question mark over the legal right of the borrower to initiate proceedings before a civil court against the bank or financial institution which seeks to recover a loan amount against it. So it's absolutely square on. This is what he is questioning my suit, which I filed in a civil court, even though his loan application is pending. Now, once if my lord comes to the first page, it's important. This appeal, my lord, just to the cause title, first page. Civil appeals decided on 10th November 2022. All the decisions my learned friend cited were before this date. So the law has changed. As per this judgment, there is absolutely no bar for any suit to be filed. I can't file, a bank can't come and file a suit for recovery of money in a civil court because that jurisdiction is there. So, or if it is, or I cannot file a suit trying to stall a legal proceeding initiated under that act. That is obvious. That is also under the general law in Specific Relief Act, I think 41 or section 41 or so, my lord, it is barred. I can't do that. So now, paragraph 1, I've shown my lord, this was the
reference.
Reference. This was the question. Then my lord will come to paragraph 5.
Paragraph?
Yeah, 5.
Yes.
But here the bank had given a loan, there were shares, then the private party filed a suit. Then 5. A crucial development took place on 18th of March 98 when the appellant, that's the bank, my lord, sold the pledged shares for a total sum of such and such and adjust the amounts against the dues in view of the authorization available.
Now, one second, Mr. Ghosh. Here, VCK was the borrower.
Yes, they pledged their shares.
Let me see. The appellant bank, Bank of Rajasthan, sanctioned a
loan to
the respondent company.
And they gave a loan. Bank sold off the loan. VCK filed a civil suit.
Bank sold off the share.
The shares, sorry.
Pledged
sold off the pledged shares. Then VCK filed the civil suit. That's paragraph 5. The respondent, as a sequitur, filed civil suit 129 of 1999 for the following reliefs. These prayers are set out. Now, just as an aside, we had just joined. Mr. Ranjan Bachawat was appointed receiver over, I think that time it was 1 crore of shares. and he became the best customer in Jodhpur Park. He was like the first time we heard that the bank manager used to come to his house to get his checks signed. So, because all that money that was from the sale of these shares were with Mr. Vachawat. I remember
Let's see the
name
prayers.
for that. That's the press. Declaration that the shares were void, etc.
Now, one second. Declaration that the sale
Sale
of
of
shares are
shares
void.
was void.
A decree
Then the
for
decree
return
to
of
return
pledged
the pledged
shares. Declaration that no sum was payable by the respondent to the appellant
Absolutely
in
bang
respect
on.
of the term loan dated such and such and overdrawn account such and such,
Yes.
and that the appellant was not entitled to a decree
decree.
for a sum of rupees such and such.
So, Maharaj, this is straight on. Absolutely challenges the loan proceedings that were going on. That you cannot go there, and what even if you've sold it, that is an illegal sale. And it was ultimately held this suit is maintainable after so many years.
No,
because the law was against this.
But Mr. Ghosh, here the contention of the borrower was that I have paid off whatever way, has to be.
Yes.
It was paid off.
And therefore you could not sell my shares.
That's right. So the loan was paid off by whatever way.
Yes.
It might so happen that by selling of mortgage property, it might so happen by direct payment, whatever way, the loans stood squared off. Therefore, you could not raise your hands so far as the pledged assets are concerned, which are the securities against the loan.
Yes. So those are the facts of that case. As I'm relying on this for the principle that any civil suit can be filed.
Not any civil suit. When
Your
you are
Lordship
relying on, yes,
Your
I
Lordship
will.
see. Previously, it was that if this could have been taken as a counterclaim or a defense.
I am not on Obijit tree.
Yes. So this
I'm not on Obijit tree because that counterclaim provision then incorporated in the act. So I'm not on that.
Yes.
I am saying that this suit was, the subject matter of the suit was, or the cause of action was, since the loan has been squared off, how could you lay your hand on my pledged assets? That's the contention in the plaint.
Yes.
Yes, sir.
And in our suit, it is since you have agreed to a 56 crore thing and I have acted on that and I've paid you and I'm willing to pay you that amount, how can you withdraw that and file proceedings and continue your proceedings against me for much bigger amounts? Then, my lord, will come to paragraph, please. Paragraph 6. So 16, I'm sorry, ma'am. That's what are the questions that came up before this?
1 second.
Because there were
16.
Yes.
Yes.
16. So this is by reference because there were many conflicting decisions, etc. Thus, in the reference order, it is mentioned that subsequent to Ranjan Chemicals, another division bench in Nahar Industrial, etc., held that the decision in Ranjan Chemicals could not have departed from the decision of Indian Bank. Indian Bank is ABS Marine, where they said that, of course, you can file a suit, but in certain conditions, the suit will be transferred back to DRT. Both these contentions.
This transfer provision was held to be bad
in this suit, in this judgment.
Absolutely.
And
because there was no transfer provision embodied in the act. Now, Mr. Ghosh,
not in the act, in the High Court, like in a commercial court.
That's right.
There's a there.
I tell you, no.
Commercial court, there's a transfer provision.
If it is a commercial suit pending elsewhere, that's not the issue. You remember those days. Now we can say in our days.
It's still hard.
Both of us, we can say. When this act of DRT came in effect, lot of matters were filed challenging the virus. Another lot of matters were filed under clause 13 of the latest patent, read with section 24. That transfer that, try it here for whatever grounds shown. Some of them were transferred initially, but since clause 13 order direct SLP was preferred, they were all dumped and finally ended with the finding that this is a statutory procedure which cannot be transferred. That's the first principles of law.
Absolutely.
Maybe the discussions so many,
Yes.
but the first principles of law was it's a statute procedure under a special statute.
Yes.
Special jurisdiction is created. How can you transfer? You don't have that jurisdiction.
Absolutely. So that section 34 will come straight on the point that you cannot file a civil suit. So obviously you can't hear a civil suit either. So these are the issues that were there. It's important. It was thus concluded that there existed a difference of opinion between several benches of this court on this issue, and it would be appropriate to refer the following questions to a larger bench. So these are the questions. Whether an independent suit filed by a borrower against a bank or a financial institution which has applied for recovery of its loan against the plaintiff under the Recovery of Debts Act, so it's absolutely on same footing as us, is liable to be transferred and tried along with the application under the RDB Act. That's number one.
That's not
He's not asking for transfer. He's asking for dismissal.
That's not our requirement. Next.
If the answer is in the affirmative, can such transfer be by order of court only with the consent of the plaintiff? Then C, this is important. Is the jurisdiction of a civil court to try a suit filed by a borrower against a bank or financial institution ousted by virtue of the scheme of the RDB Act in relation to the proceedings for recovery of debt by a bank or financial institution? Just like your lordship just felt that clause 13 at that time, it was ousted because of this jurisdiction. Now the question is, can a civil suit filed by a borrower, doesn't say what suit, what was the facts of that case, that is irrelevant. These are questions of law that had been referred for reference. So even the prayer in VCK, if it can be distinguished from us, if they try to do it, that would be irrelevant. Because these three questions, how did they answer? Question number one, we are not so much concerned with, so I'm not placing that part. Now, if my lord comes to paragraph 38. Before that, page 16, just one page before, paragraph 35, the bar under the RDB Act is set out, section 18. No court or authority shall have or be entitled to exercise any jurisdiction, powers, authorities, except Supreme Court and 226 in relation to matters specified under section 17. Then if my lord comes to paragraph 3, then the whole section 19 is also set out, the entire scheme of the act is considered. 31. Then paragraph 38.
38?
Paragraph 38. Really quotes from that ABS Marine. The interplay of the...
One second, 38. Yes. Yes.
It is also important. The interplay of the provisions of the RDB Act and the Code has been discussed in the aforesaid judgment of Indian Bank's case. We find it appropriate to extract paragraphs which deal with this aspect. Remember, this discussion, this part of ABS Marine was upheld, I think. Now 39. I'm not reading out the whole thing. But like I told my lord, that what ABS, that Indian Bank's case decided was, in some cases, it can be transferred if it fits. 39. On a plain reading of the provisions, the conclusions reached was that section 17 of the RDB Act bars the jurisdiction of civil court only in respects of application filed by the bank or financial institution. This provision did not bar the jurisdiction of the civil court to try a suit filed by a borrower. There is also an absence of provisions in the Act for transfer of the suit and proceedings except under 31, which relates to pending suits proceedings by banks for recovery of debt. So that is clear. Just if I stop here, alone this application should go because they have only pleaded 34 and they've only referred to vaguely as this section 18 of this RDB Act. Because they say we have filed where this suit is not barred, is barred. Then, so then 41, these are the decisions they are taking into account. The question thus arises.
Where?
41.
41.
The question thus arises as to whether the view expressed in Indian Bank is the correct legal position in view of certain earlier judgments and as well as certain, which should be later, it's gone along as latter judgments. We may, however, notice that the earlier judgment in OBGT, where an independent suit of a defendant is deemed to be a counterclaim and transferred to DRT, was considered and differentiated. So ABS Marine, that distinguished that already. Although both were judgments of coordinate benches of this court, Indian Bank opined that the transfer would only be possible if the subject matter of the two suits was inextricably connected and where both parties consented to the transfer. So this was the problem. Now our view, paragraph 43. Right, the last Yes, nearly there. 43. We must note at the threshold itself that there are no restrictions on the power of a civil court under section 9 of the code unless expressly or impliedly excluded. 1. Then this was reiterated by the Constitution bench in Dhulabai's case. Thus, it is in the conspectus of the aforesaid proposition that we will have to analyze the rival contentions of the parties set out above. Our line in thinking is also influenced by the three-judge bench in Dwarka Prasad Agarwal, where it was opined that section 9 of the code confers jurisdiction upon civil courts to determine all disputes of a civil nature, unless the same is barred by statute, either expressly or by necessary implication. And such bar is not to be readily inferred. The provision seeking to bar jurisdiction of a civil court requires strict interpretation, and the court would normally lean in favor of a construction which would uphold the jurisdiction of a civil court. So, number one is that he has a very high threshold to say that this is barred. Like, your lordship doesn't have jurisdiction to hear my suit. Now, if we turn to the objective of the Recovery of Debts Act, read with the scheme and provisions thereof, it is abundantly clear that the summary remedy is provided in respect of claims of the banks and financial institutions, so that recovery of the same may not be impeded by the elaborate procedure of the court. The defendants have the right to defend the claim and to file a counterclaim in view of subsection 6 and 8 of 19. In case of pending proceedings to be transferred to DRT, section 31 took care of the issue. These were the suits that went. Then, thus, if a debtor desires to institute a counterclaim, that can be filed before the DRT and will be tried along with the case. However, it is subject to a caveat that the bank may move for segregation of the counterclaim to be relegated to a proceeding before the civil court under section 1911, though such determination is to take place along with the determination of the claim. So even when the claim is being determined, under the statute gives the bank to say that let's sever this, relegate it back, and let him pursue his suit in the civil court, give me my award here. We are thus of the view, 45 minutes, thus of the view that there is no provision in the Act by which the remedy of a civil suit by a defendant in a claim by the bank is ousted. But it is a matter of choice of that defendant. Such defendant may file counterclaim or may be desirous of availing the more strenuous procedure established under the code. And that is the choice which he takes with the consequences thereof. We may notice that the RDB Act was amended from time to time, including amendments made right up to 16. The anomaly inter alia initially sought to be cured was on account of the non-availability of provisions for counterclaim and set-off. It is to get over such scenario that the amendment through Act of 2000 was made by the legislature, because that time they didn't have the right to entertain a counterclaim. The legislature did not at any stage make any further amendment for excluding the jurisdiction of a civil court in respect of a claim of the defendant in such proceeding being filed along with the suit. The legislature, in its wisdom, has also not considered it appropriate to bring any amendment to enhance the powers of DRT in this respect, for transfer, etc. Then we also refer to the judgment in Transcore, opining that the DRT is a creature of statute and does not have inherent power which inheres to civil courts under 151. Then further discussion is made. Now, paragraph 51 is to do with the transfer. I'm not going into that. Paragraph 52, if my lord comes. Just the end of the judgment. 52. We, however, have a word of caution, keeping in mind the nature of the powers exercised by DRT and its object of its creation. The interpretations in OBGT and Ranjan Chemicals seeking to give power of transfer to the civil court, whether by consent or otherwise, were apparently predicated on the apprehension that a defendant may launch a suit before the city civil court in order to delay the proceedings before the DRT. Now, we certainly would not like that the process envisaged under the RDB Act be impeded in any manner by filing a separate suit if the defendant chooses to do so. A claim petition before the DRT has to proceed in a particular manner and would proceed. So that is the scheme of the statute. There can be no question of stay of those proceedings by way of civil proceedings instituted by the defendant before a civil court. The suit would take its own course, while the petition before the DRT would take its own course. We appreciate that this may be in the nature of parallel proceedings, but it is the defendant's own option. It's up to me, my lord. Then
Where?
Paragraph 53, right in the middle, placetum C. We appreciate this may be in the nature of parallel proceedings.
Correct.
But then it is the defendant's own option. We see no problem with the same as long as the objective of having expeditious disposal of the claim before DRT under the RDB Act is not impeded by filing of the suit, filing a civil suit. Thus, it is not open to a defendant who has taken recourse to a civil court to seek stay on the decision of the DRT awaiting the verdict of his suit before the civil court, as it is a matter of his choice. Then, we thus make it abundantly clear that in case of such an option exercised by the defendant who filed an independent suit, whatever be the nature of the reliefs, the claim petition under RDB would continue to proceed expeditiously in terms of the procedure established therein to come to a conclusion whether the debt is due to the bank or financial institution and whether a recovery or certificate ought to be issued. So there can be no stay of their suit. I have not asked for stay of their suit. We may say that if the legislature were to think otherwise, nothing prevented the legislature nor prevents it now from making suitable amendments to the RDB Act to meet such a scenario. In view of the discussion above, the questions framed are so answered. C. Is the jurisdiction of a civil court to try a suit by a borrower against a bank ousted, etc.? The aforesaid question ought to be answered first and is answered in the negative. So there is no bar to my suit. As far as the law that concerns my present application, there is absolutely no what the effect of it will be, whether I'm trying to stall the DRT, etc. That will be taken up before those tribunals. They will decide. If your lordship is in season of a matter, if they want to go ahead with it, they will go ahead. But if I get my decree, if there's a declaration that this is that letter I showed you on 31st December, they agreed, they told me pay 1 crore, I paid it. Now the subsequent 2 letters, they say, no, you pay 20%. I've even paid that 20%, but that's later. That is a subsequent fact, it's not on record here yet. So this is the first question. C was I'm concerned with. The Supreme Court has decided in its reference clearly. Then question B also is decided that there has no power of civil court to question the suit, whether by consent or transfer the suit, by consent or otherwise. Even by consent, it cannot be done. The 57, the aforesaid takes care of the reference.
The transfer is, if the order of transfer is inherently without jurisdiction. Order of transfer, inherently without jurisdiction. The civil court cannot, even by consent.
No, not transfer from there to here. But what about the suit I have filed? This cannot also be transferred as a counterclaim.
Counterclaim.
That earlier, the view under clause 13, probably because your lordships have the inherent power, which the tribunal doesn't have. Well, the factual scenario, just since your lordship brought it up, 58 last. So I am really concerned with the legal proposition of law, and I think this is a complete answer to this present application. Now, as far as the merits of whether the OTS was concluded or not, I have shown my lord prima facie that it was concluded, and the very letters that my learned friend has placed, those are the letters in my prayer D of my plaint, because I have said I have been forced to write those, and it's completely contrary to the stand taken by the bank, because I have paid the 10% eligibility which I required to pay. I have paid that in 2022. Then for some reason it fell through. So they're saying, no, again you have to pay. And in fact, we have deposited, but that's, your lordship need not go into that. That's the subject matter of my suit. May I just place the 58 just for conclusion? Now, coming to the factual scenario of the case, the fact is that the proceeding under the RDB Act in any case have reached a culmination with the satisfaction of the claim, and thus no proceedings instituted by the appellant are pending. As for the suit, there is no question of a counterclaim or transfer of the same in any manner other than by trial of the suit instituted by the respondent. In fact, some part of the claim of the bank was not even allowed, and some adjustments were directed to be made. Even thereafter, as far as the other claims of the respondent are concerned, DRT, in terms of the order dated such and such, permitted the respondent to pursue the remedy in accordance with law, which only means the civil proceedings. The suit is thus liable to be proceeded accordingly. Here the DRT proceedings were over, and the DRT said the rest of your whatever objections you're taking, you have been given liberty to file a civil suit. And they did so. And then this reference came up, and the judgments of Obijit T and Ranjan are held to be not laying down the correct legal proposition. And judgments of Indian T are affirmed except to the extent they allow transfer. So a civil suit is maintainable on the pleadings I've shown, and this logic will also apply to section 63 if they so choose. They haven't pleaded. They merely said you're using this as a ploy. They want some observation in their application that they can show the tribunal. I am free to take whatever decision I want. But on the face of it, if my lord sees the facts, this is in my affidavit opposition, I have dealt with all the facts, and I brought this all to the notice of the court. Everything that my learned friend cited before my lord, the page numbers, all these are there in my affidavit oppositions and in my.
I'm not on suppression.
Yes.
I'm not on suppression.
So this now to deal with the cases that my learned
I'm not
friend
on suppression for a moment.
So is it your lordship's pleasure that I place the judgment? What is section 7? Because that time it was more of an academic question. What
Not
is the
required.
scope of section 7? There are some judgments which it's a law.
You
It's
give
really
me the
not an
best
issue.
one. You give me the best one. According to you, which is the best one?
Very
You
well.
give me.
Well, I'll come to that one. May I finish as far as that is really of academic interest? But my thing is this suit, whatever prayers I make in this suit, there is no thing that there is no
Scope of being barred by law.
No scope of being barred. And even if by analyzing my prayers, it doesn't come under the provisions of the SURFACE, doesn't come under RTP, and also IBC, even because they've argued it. Though I've shown, they have not pleaded it. They have not pleaded that this is not. And it's surprising that a bank will pursue liquidation proceedings when all this has been done for their benefit. The whole tribunal system has been set up. Now, if my lord sees the judgments that my learned friend cited, first was 2018, 8 SCC, page 120.
1 second. 2018?
8 SCC, 120.
Yes. Paragraph 8 he cited, but what was the issue? This was a case of writ petition.
Yes.
The submission of my learned friend, of course, that time we didn't have the judgment, but the submission was that I am not entitled to any relief. No relief can be got if it will interfere with the other proceedings, with the bank tribunal proceedings. This was the proposition why he tried to cite this decision. Now, first thing of this decision, I want to show again from the beginning that it was passed in 2018. So there is, after this decision of the the larger bench, there is no question of any of these. If there are any observations, I have not gone through it detailed wise, but in any event, that bar that existed in OBGT and Ranjan Chemicals and etc., those have gone. There's no analysis. Now, paragraph 6, what was the issue in this suit, in this proceeding? Sir, read.
In the writ petition.
Yes.
So there the constituent had filed a writ petition asking for more time and wanting to hold discussions for settlement of the dues. And the High Court passed within 8 weeks, you must approach the proper forum and get adjudication. That was the finding. Now 6, the bank has assailed the aforesaid decision of the High Court primarily on the ground that all issues concerning the mortgage and secured property are required to be decided only by DRT and not in civil proceedings as observed by the court in the impugned judgment. For filing of a civil suit in respect of secured assets is barred by law. Now this, I think this is in doubt now. Then secondly, DRT as well as DRAT have examined the merits of the controversy and justly answered the same against the writ petitioner. The concurrent findings of fact recorded by the tribunals is that the writ petitioner failed to establish any right, title or interest in the subject flat. That finding has neither been disturbed nor is it assailable. According to the bank, the High Court judgment under appeal is untenable and deserves to be set aside. So the factually, it's completely a different scenario. Here, the mortgage property is not an issue in this suit. The OTS does not take care of the mortgage property. This is in addition that our claim was that 95 crores of money that I have taken, out of that 55 I have returned, 55 is 35 I have returned and 55 is left. Then paragraph 8 was placed. After having considered the rival submissions of the parties, we have no hesitation in acceding to the argument urged by the bank that the mandate of section 13 and in particular 34 of the SARFAESI Act clearly bars filing of civil suit. For no civil court can exercise jurisdiction to entertain any suit in respect of any matter which the DRT or DRAT is empowered under the Act to determine, and no injunction can be granted by any court in respect of any action or taken in pursuance to any power thereof. So this was the interpretation of the law stood at that time. Then paragraph 10, the learned counsel appearing on behalf of the bank persuaded us to decide the matters in controversy between the parties. But as noted earlier, the High Court has
not only that. The Lajavin said,
any suit.
Yes. Lajavin said, it is the option for the defendant either to lodge a counterclaim, because your suit, the claim in your suit could have been lodged by way of a counterclaim.
As a defense, can't be counter. They cannot declare those letters which I'm saying by coercion.
Right. At best, you can say that there has been the OTS settlement.
Now, your lordship will have to be clear who can decide, the NCLT or the tribunal, the debt recovery tribunal. Again, these two have completely different powers.
And
NCLT cannot.
Different jurisdiction, scope of the statutes are different.
Even deciding the adjudication, now I'll place that decision tentatively, of course, because I also this thing, I'll place that decision. They are not adjudicating a debt. It's not the simple winding up that we used to do, and then we go into the whole hog and say, is there a debt or not? And if so, how much? And when
they have to adjudicate.
When will you pay is also gone.
NCLT under IBC has to default. Whether it's a default. If the default, then the process will follow.
Yes.
Statutory scheme.
Then it will go down that path. That's the thing. So I can't go and say you adjudicate, is there a default or not? There is an agreement that I want to specifically perform. You agreed. I changed my position. Now again you've changed. There's a series of correspondence.
And no, not only that. But under IPC, there is no provision for entertaining counterclaim. There is no provision under IBC.
Under IBC?
Yeah.
No.
Absolutely no.
No.
Absolutely no. It cannot be.
It's a defense.
Absolutely.
Raise a defense. Now then.
Yes.
So what they did the Supreme Court did in this matter is that paragraph 11, if my lord comes to 11 and 12. We find force in the submission on behalf of the bank that the High Court could not have directed the bank to deposit 25 lakhs in an interest earning deposit and the profits of the deposit to inure to the benefit of the successful party. Such direction is wholly uncalled for. Be that as it may, since we are setting aside the impugned order of the High Court, we direct writ petition such and such to stand restored to the file of the High Court in its original number for being decided on merits and in accordance with law. As the proceeding for recovery is pending from 2010 concerning an equitable mortgage created by respondents in respect of the subject flat and having failed to repay the loan amount, which is quite substantial, we request the court to dispose of the. So the writ petition was also held to be maintainable. Writ petitions are always maintainable because it's the power of your lordship's discretion that will decide whether you entertain it or not. So this case really doesn't help my learned friend in any way as far as this Order 7, Rule 11 is concerned. This was cited that Supreme Court set aside the direction of the court, which says, no, you put the money in a fixed deposit right now and let them decide the issue.
No, they cited because of the paragraph 8.
Yes, paragraph 8, which just reiterates section 34,
Absolutely.
which has been totally considered.
And that is absolute bar. If your suit, as you are arguing, if your suit is framed in such a manner.
If I was a bank, I would be gone. But
No.
that's it. I would have no
Had
choice.
there been a declaration that 13(4) steps are banned?
Yes.
Then
If I was trying to stop that.
Then of course 34 comes into play.
Yes, maybe. I won't get that injunction, but whether the suit becomes, I lose the suit maybe if it is like that. But as far as maintainability of the suit, I can file a civil suit because that act doesn't force me to file a suit before them, before that tribunal. So that is the issue. So here, even after being informed on the last day that there's this division bench judge, there's this special bench, this should not have been cited. But anyway, that's Mr. Mukherjee wasn't there, so I'm not saying it. If the law has changed, I'm showing this law which has come after 18, now it's come in 2023. There was confusion, I would give that. There was, all of us were, it all depended on whether it's actually you're disguising or creating a clever drafting is creating a cause of action, etc. Now, I think this judgment is very clear that as far as 34 is concerned, doesn't stop me from filing this particular suit for a declaration and for injunction. If I wanted a direct on the proceedings, that would be different, even if it concerned the same subject matter of the property. But I'm telling my lord that this is nothing to do with the immovable property, my suit. My suit, the OTS has taken into account that the property worth 40 crores is secured. And the bank itself, the attempts my lord had noted, they have been attempting to sell it right up to 2013.
5 times.
My pleading is 13. He said 10 to 15.
10 to 15.
He said 10 to 15. Because that last one I didn't have. We in our pleading, they've last tried in 17. But my learned gave another.
The next two judgments?
21. Right. Then, my lord, the next decision is 2023 1 SCC 540.
No, first they have cited 2023 2 SCC.
Yes, 2 SCC, page 805.
Sir, in this you wanted to show the date. Though it's 2 SCC, it's predates our one.
So, my lord, again, beginning at the beginning, this was a judgment delivered on 15th December 2021, reported in 2023, no doubt. My lord will see. So, it is previous, before that decision. Now, here, this is the case where she was not eligible.
Yes, paragraph 2.2. Sorry.
Here, my lord, the question of him being eligible at all for an OTS was an issue. I don't want to go down this rabbit hole because I've shown my lord, page 146. We were given an OTS. Whether we complied with the terms and conditions later and according to the bank, they've revoked it, which we are challenging today, those letters. At page 146, there is no ground of the bank that we were not eligible. The paragraph 2, your lordship will see. 2.1, sorry. One-time settlement scheme was issued by the bank, OTS circular such and such, which provided that on the conditions contained in the circular being complied with, the benefit of the OTS can be taken by the debtor. The benefit of the OTS was extended till such and such date. The original writ petitioner submitted the application for consideration under the OTS. By a communication of 17 September, her application for grant of benefit under OTS was rejected on the ground she was not eligible for OTS and that the loan can be recovered by auction of the mortgage property. That there are chances for recovering the loan amount and a loan has been declared NPA. It appears that to come out of the NPA eligibility, the writ petitioner deposited 60 lakhs after rejection of her earlier application on the ground that her application is NPA and she is not eligible for OTS. The board passed a resolution to the effect that the
Where?
2.2 that the original writ petitioner is not eligible for the benefit under the OTS scheme for the reason. So this is really on the merit, whether I'm entitled. It doesn't say under any stretch of imagination that OTS schemes cannot be enforced by a court as a normal contract. We are pursuing the matter. It is a contract between two parties at arm's length. You have agreed to it. I have acted on it and I want specific performance of it. I want a declaration it's concluded because now you are raising, you're threatening to deny or you're denying my right of this contract after having accepted the offer and I having acted upon your acceptance. Then, my lord, so now if my lord comes to paragraph 6, having heard the learned counsel for the respective parties at length, the following questions are posed for the consideration of the court. Whether benefit under OTS scheme can be prayed for as a matter of right, whether the High Court under exercise of Article 226 can issue a writ of mandamus directing the bank to positively consider the OTS scheme. Dehors the eligibility criteria. This is completely a different issue. Their Order 7, Rule 11 is not that I was not eligible for OTS. What am I talking about? This is no OTS. So this decision and the point of law also is completely, my lord, irrelevant for the purposes of Order 7, Rule 11. Whether they can show and demonstrate in the suit whether I'm eligible or not, that's a different matter. But prima facie, I've shown my lord the document. The bank itself has invited me and says, no, don't make 55 crores, make it 56. I make it 56, they advance 1 crore. I've advanced 1 crore. Then they come back after a month and say, no, you give 20%. And we say, but we've given 20%. And they make us write a letter that we will give 20%. It was 3 crores. By this time, we have also, in fact, deposited that money, but that is neither here nor there. By 31st December, I had said I will pay off this 56 crores. And that would settle the bank's dues once and for all in 1 year. But they have chosen, no, this is now it's gone through. I'm going to ask for my 170 crores or whatever it is. And that includes the mortgage property. Mortgage I've given him. He's meant to sell it, but that's not the subject matter of the suit, nor is it the subject matter of the Order 7, Rule 11. So I really don't want to make any submissions as far as the OTS is concerned, except to say that this decision does not lay down any proposition which makes my suit bad in law. On the facts of that case, the writ petitioner was held not to be eligible in the first place for whatever reason. That is an issue is completely different. And if my learned friend is correct that I am not eligible, that will be fought out in the suit.
That is against the stand if they say that I'm not eligible.
Yes, they have given me OTS twice. The first one, unfortunately, I couldn't keep they withdrew. That's all there in their pleadings. They withdrew the IBC proceedings initially. Wait, let me finish this. Did he cite these?
Yes, he cited 5.8, 5.1. That's a submission 8, 11, 12. 5.1 is the submission of the bank.
Now, if my lord comes to the conclusion.
1 second, sir.
Yes.
Is asking me to show you section
E.
E. Answer is asking me to show you section E.
Where is the second rejection? That reiteration of that letter?
My learned friend showed 151 and 148.
148 and
146 was what is the
and 151.
151.
The second rejection is at page 153, which is under challenge.
Yeah, it's under challenge.
Once here,
Painted there.
No, 151 is your letter.
I'm sorry, 153 is the purported rejection, which we have challenged. In my prayer, my Lord will see, page 55. 13th, yes, 153 is their letter where they finally say that
not acceptable.
first part is to do with mortgage, the last part of the letter, 154. The rejection is basically that upfront payment is the last two lines is not in line with the bank's policy. Hence, OTS is not.
And not only that, this OTS was not there in terms of any announced OTS scheme.
The second time, yes. The first time probably was.
First one has gone.
Or it was a continuation. There was 95.
That's all right. First time has gone. Otherwise, it is already finished. It has finished its life. Otherwise, why would you apply for the second time? But the thing is, in the second OTS, that is not under any RBI guideline or any statutory guideline.
Things to that effect. It doesn't appear from the letters. It's what we are treating it as they were promises that were exchanged and it was accepted and we have acted on that promise. So that's on the merit. Now my Lord will just make a note of that, page 55, if my Lord comes, the prayer D. Delivery up and cancellation of the letters of the plaintiff. This is page 151. My Lord has page 55. Just make a note, the first letter, 5th February 2025, is at page 151. Then the next letter, 18th February, is at page 155. These are our letters. Then defendant's letter, 21st January is 148, and the next one is 153. And there's one more letter, 19th February. Again, they reiterate that we are not going to honor the OTS. That's at 204. And these three letters that they have given are the subject matter of challenge in our suit. Because once, if I accept those letters, then I have no case. You have changed your stand subsequent to December 31. But all these, I would say, my Lord, is a mere distraction from the real scope of Order 7, Rule 11. I think this decision of the three-judge bench, my Lord, decides it comprehensively. What's the last one?
Last one is 2023 1 HCC 540.
Yes.
This is also predated. It's 4th November. And this follows that 2023 Meena Agarwal's, which you just had distinguished this one, which is on a different premise.
This case, the 2020 3-2 SCC, which I am citing, is that Meena?
2023 2 SCC is Meena.
Meena.
Meena Agarwal, which
is yes, Mr. Ghosh.
The last case which I was distinguishing, my Lord, it's
no,
not.
Wait. So you have done with 2023 to SCC 805.
My last comment on that is it's not an authority for saying that an OTS scheme cannot be enforced by a court. There the question was of the eligibility.
The question was in paragraph 6.
Paragraph 6. depending on the facts of the case. And then the writ petition was ultimately relegated back to the High Court to decide like that. The High Court said, had put some terms. They said put in 25 lakhs now and let them decide. And it was only on that direction of putting in the money and deciding how much money should be put in now and what should happen. That is what was set aside by the Supreme Court and said, no, let them reconsider this matter there. So this is not a final proposition that a suit filed for enforcement or specific performance of a one-time settlement agreement entered into parties is not maintainable. Under the Specific Relief Act, under the Contract Act, I am entitled to file a suit. And that's all the little scope I have for defending today. As far as when I GA1, when I seek my injunction, when I press for injunction, all these problems I will have to face. That whether they can do that or whether they can't. But this mixing up, then at that time, we will tell you a lot about the real facts, because the mixing up of the mortgage and this one-time settlement, they're two different things. At least that's my understanding of reading the papers. And it's also not the case that I'm interfering with the mortgage. That land they will sell, they will get their money. And as far as this is concerned, it was 95 in 2022 when we came to the first settlement. We have paid. Now there's 55 left. They said make it 56. We said fine, and we paid the money. Then these letters come. They have ultimately rejected. It's their choice. But those are the letters that are under challenge. And it has nothing to do with the suit, in the sense that, of course, it has to do with the suit, because if you can't, in one forum, you can't say that I have entered into an agreement, you pay only 56 crores, and then pursue a claim for 150 crores against me. 1 crore for 149 crores. Finally, my lord, the last decision, 2023, 1 SCC 540.
Date decided on. 10 days.
This again, my lord, your lordship will note 4th November 2022. The decision of VCK was of 10th November.
14th.
Of 10th. 10th November.
Yes.
Extension of OTS. So by MR.
Again, this was a writ petition. The court said that we give you 6 weeks time to make the payment. And they went up to Supreme Court. And paragraph
12 and 13.
12, my lord.
12 and 13.
Paragraph 12.
12. At the outset, it is required to be noted that by the impugned judgment, the High Court extended the time by a further 6 weeks from 10th of March in favor of the borrower. Original writ petitioner was to make balance payment, which was due under the sanctioned OTS scheme, which was sanctioned in 2017 and in exercise of powers under 220. So under 226, the payment he was to make in 2017 was extended in 2022. This was the grievance. Therefore, the short question which is posed for consideration is whether the facts and circumstances of the case, the High Court was justified in extending the period to make the payment of balance sanctioned under OTS beyond the time granted by the scheme of the OTS, sanctioned OTS scheme. Then paragraph 16, they follow Meenal Agarwal, the earlier case, and it says, yes. Of course, it was his lordship's own judgment. It was his own judgment.
Huh?
I think it's Justice M.R. Shah is the
author of, yes.
That is why that was got in here. That on the detailed analysis of the OTS scheme, it is observed and held by the court in Meenal Agarwal, no borrower can, as a matter of right, pray for grant of benefit.
Where?
Paragraph 16.
Yes. Yes, that's the, yes.
Then the grant of point number 3, the grant and benefit of the OTS scheme is subject to the eligibility criteria and guidelines issued. No writ of mandamus can be issued for the benefit of the borrower. That was the finding. And again, there was a writ petition. Again, it allowed it. So then it was allowed. And the writ petition was dismissed. and the parties were left to their own.
Paragraph 26 dismissed. So the extension of OTS. This means the extension of OTS.
For us, the OTS has been concluded. Payment is 56 lakhs. Now, in my affidavit opposition,
Yes.
affidavit opposition, just in case my lord wants to see it.
So what is your, crystallize your point on this last judgment you have distinguished?
But both these decisions relate to the orders passed by the writ courts, and it does not say that a suit for specific performance filed by a borrower is not maintainable and it can be rejected at the outset as an order as is barred by law, as it were. It's very carefully worded. Both the decisions, they said, on the facts and circumstances of this case. One was to do with the very eligibility of the lady, to whether she comes under that, whereas here the OTS proposal was accepted by the bank itself. That letter cannot be got around so easily, my lord. You'll see the letter at 146 again. This is in reference to my learned friend placed the letter at 141, and their reply is this letter, 146. This is in reference to your letter where you have increased the OTS.
Slowly.
From 55 to 56.
146.
146 of GA2, yes.
Yeah. Yes.
Yes. That is the letter of the bank. They don't say you are not eligible for OTS offer, etc. You have increased the OTS offer and this is being discussed. We advise you to deposit 1 crore. This is on the merits. Then they'll say the next letter, if my lord sees of the bank.
You are hereby requested to do the needful to enable us to proceed further.
Yes. So I put in the 1 crore. Now the letter at 148, my lord will see. But my lord, your lordship is dragging me into the merits. I don't want to go there.
No.
I'm not, because I haven't seen all the correspondence yet, but I'm tentatively showing my lord. Prima facie, page 148.
Yes.
Now they changed the upfront payment date. We refer to your compromise proposal of 56. It was my proposal was for 55. They asked for 1 crore. I paid them 1 crore extra. Then, as per bank's policy, 10% of OTS amount to be kept as upfront payment for the credit to the loan account.
So the policy, if a policy is there, that cannot be changed either by the bank or by the borrower. If a policy is there.
But if it's an agreement between the two parties.
That even cannot change the policy.
No, but as far as the policy is concerned, they say that if the customer is not ready to deposit the above 10%, then 25% is to be kept in a no-lien account as upfront payment. However, you deposit 2 crores only. That earlier letter said to deposit, we put 1 crore in first. Then the earlier letter says, please put another crore. So I put in another crore. Then they change the thing and they say you put in about 25% must be in a no-lien account or you put upfront 10%. Now 25% of 14 crores I have put in. That is my supplement. If my lord wants to go down that way, in my GA1, I will definitely bring it on record that I have also put in that.
Yes, that supplementary affidavit in GA1, yes.
This letter of 21st January 2025 is the subject matter of my suit. Page 55. 21st January 2025. I'm saying this letter is denying my right that there is already a concluded contract. You can't change it. And this is to do with deposits. In another 1 month, I'll have to pay off this entire amount. Otherwise, it's a question of, I don't know what's going to happen. Because our thing was we will pay off by 31st December of 25, we would have paid off this amount. So we've deposited, we've made some payments, we've deposited some payments. The property is still not sold. That's another subject matter.
Oh,
But that is on the
neither here
further
nor
view
there.
of things. No, it
Neither
is
here nor-
necessary to show, my lord, that we are not fly-by-night persons and we are not defrauding the bank in any way. This is an agreement with the bank we are trying to enforce, that you cannot play fast and loose with your customer. I may be right, the bank may be right. That's another issue. But this is not an attempt that submission is made. They owe us 150 crores. They are only trying to pay 56 crores. Who has asked us to pay 56 crores? That was the scheme. That was the settlement offered. That's what I offered. You agreed. You said, no, you put in a crore. I put in a crore. Now you say you put in a bit more. So those I can put in a bit more if they say that. It's my banker after all. And all my projects are going on. I'm an engineering company. It's happening. So those are on merits. In GA1, no doubt, your lordship will consider these when thinking whether or not there should be some protective order in my favor. The advantage my learned friends are taking is that he's saying that you didn't press for your ad interim order, so you're not entitled. And they're taking time.
Order 7, 11, those are no consideration at all.
So in two instances that my learned friend has cited, where the person was not eligible for OTS, for whatever reason, can that be decided without evidence? Can it be decided in Order 7 as a demo? My pleadings in my plaint are to be taken as true. It's pretty much straightforward. My job was made really easy because of this decision. After this decision, the maintainability they have pleaded, and that will apply even if my lord thinks about the IBC, it will apply there also. It's not the case in the GA2 that because they filed a proceeding before the NCLT that the suit is barred. It was submitted, didn't stop them from submitting. It stopped them. Something must have pained the conscience not to put it in the pleading. That was the submission made. Now, if does my
That's
lord
all?
want to
You have
know about
completed.
the Section 7?
Give me the judgment, sir.
So if my lord takes 2022, 3
One second.
SCC,
1 second.
161. 2022, 3 SCC, 161, ES Krishnamurthy. Now again, my lord, if my lord comes, I'll just
1
take
second.
one
Sir.
or two.
1 second, sir.
Two per. No, one also.
Two, sorry, 3 and 34. 3 is the issue.
Yes. 2022 law. Mr. Ghosh.
Yes, 2022, 3 SCC, 161.
Paragraph. Paragraph.
Paragraph 2, 3, and 34. Just only on the scope of, or if my lord is going to read it in your lordships, and then 30 to 36. I'll place 34 to give fullness of it. So paragraph 2, my lord. On a petition which was instituted by the appellants under Section 7 IBC.
The IBC has changed a lot. Sea changes after my elevation.
Yes. And especially it's gone another ocean away.
Ah.
Now we don't
The
have
lot I did all before 20, it is changed now.
Right. Paragraph 2. This is Justice Chandrachud. On the petition which was instituted by the appellants under Section 7 for initiating corporate insolvency resolution process in respect of the respondent, NCLT declined to admit the petition and instead directed the respondent to settle the claims within 3 months. NCLT found no merit in the appeal against the order. So ultimate finding here is you don't have jurisdiction to say
settle.
Nobody, you're a rubber stamp, you will decide whether there's a default or not. That is what is said. Then 3. So here the question of if I have a counterclaim, etc., it doesn't lie. In DRT still there was some background.
In DRT, it was an original proceeding. Yes. There was some grey area
Yes.
And thereafter,
And there were
by
those
way of
judgments.
amendment.
The judgments were there that ruled
Absolutely.
the
Obhijit was there, and thereafter the amendment. Yes.
the issues which arise for adjudication before this court is whether, in terms of the provisions of the IBC, the adjudicating authority can, without applying its mind to the merits of the petition under Section 7, simply dismiss the petition on the basis that the corporate debtor has initiated the process of settlement with the creditors. He said, go and solve it. Then, paragraph
32.
From 30. 30 TO 236, but I'll place only 34, but I have just take my lot to 30 first.
Yes.
Yes. Yes. If my lord comes to paragraph 30.
34, straightway you come.
No, it sets out the section. I won't read the whole thing to give it completeness.
The procedure.
The procedure is set out.
Yes, come to 34.
34, very good. No, before that one important, but 31. If I
Yes,
start
yes,
that.
yes.
On a
31.
bare reading of provision, the section 7 is really discussed before that.
31, yes,
31.
yes.
On a bare reading of the provision, it is clear that both clauses A and B of subsection 5 of section 7 use the expression "it may by order" while referring to the power of the adjudicating authority. In clause A, subsection of 5, the adjudicating authority may, by order, admit the application, and in clause B, it may, by order, reject such application. Thus, the two courses of action are available to the adjudicating authority under section 7. The adjudicating authority must either admit the application under A or it must reject the application under B. The statute does not provide for the adjudicating authority to undertake any other action but for the two choices available. That's a very limited scope. It's there. They will say, do you owe a debt? Do you admit the default? Then you're passed on to the CIR.
If you admit, then you exercise your entire procedure.
Yes.
If you don't admit, just leave it. Throw it.
So here, when in this particular case, they had said, go and settle the matter. Then paragraph 34, that's why. The adjudicating authority has clearly acted outside the terms of the jurisdiction. The adjudicating authority is empowered only to verify whether a default has occurred or if a default has not occurred. Based upon its decision, the adjudicating authority must either admit or reject the application.
That's precise.
There are only two causes, repetition actually, which are open to the adjudicating authority cannot compel a party to the proceedings to settle a dispute. Undoubtedly, settlements have to be encouraged because the ultimate purpose is to facilitate continuance and rehabilitation. As the statement of objects and reasons accompanying the introduction and the objective of IPC is to facilitate insolvency resolution in a time-bound manner for maximization value of the assets, promotion of entrepreneurship, ensuring availability of credit and
So
balancing.
straightway you come to this. What the adjudicating authority and the appellate authority.
However, have to proceed to do in the present case is to
Abdicate.
have proceeded to do is to abdicate their jurisdiction to
Correct.
decide a petition under 7 by directing the respondent to settle the remaining claims within 3 months and leaving it open to the original petitioners who are aggrieved by the settlement process to move a fresh proceeding in accordance with law. Such action is not contemplated. Then this says IBC is a code on its own. The adjudicating authority and appellate authority are creatures of statute. Now, where is the argument that this suit should have gone before the tribunal? And there is a bar in section 7 or in section 63 that I cannot file this suit here.
Not only that, to initiate a proceeding under section 7 of IBC, there is no requirement of declaration of NPA.
No.
No declaration of NPA. Similarly, to initiate a proceeding before bank tribunal under RDB Act, there is no requirement. It is not a precondition. Only for initiating SARFAESI, that's the precondition. So they can maintain their proceeding. Jolly well. If it is otherwise maintainable within the jurisdiction of that act.
But they cannot blow hot and blow cold. They cannot say that if ultimately I'm successful in the suit, then my liability will be 56. They can go on. They can suppress the concluded contract. If it's a dispute, it will be adjudicated. Whether your lordship will adjudicate it at the interlocutory stage and give me a temporary relief, or it will be in the suit. The suit will be heard out, and that will have to. They'll have to abide by that result. It cannot be that you can say that I have to pay 56, and that becomes 150 crores.
Thank you.
So, those are my submissions. Well, as far as GA1 is concerned, my lord will keep it either next week.
I'm not keeping it.
I think
Till I decide this.
in the list.
Till I decide this. Because that has to be the procedure to be followed. Because it is a jurisdictional application.
Very good.
Thank you, Mr. Ghosh.
I'm grateful.
Yes, Mr.
Only
Mukherjee.
restricting to what has been submitted.
Only the cases.
Only the cases.
One case of
Only the larger bench.
Absolutely. VCK share trading case, my lord. VCK share trading case.
1 second. Yes.
I personally had the occasion to assist my senior. He concluded his argument before his election.
This matter. Yeah.
Not in the Supreme Court. When it went from
Okay.
our High Court,
Whatever.
Justice
No matter.
Now
Proceed.
for the bank.
who lost. I'm saying for the bank.
Yes.
There the issue was bank filed an original application before the DRT. VCK instituted a suit in this honorable court, whether that suit independently could be maintained or not. The bank's contention was, since bank had already filed the original application under RDDB Act, the borrower is obliged to go before the DRT only. There the issue was confined to that portion, and that is why the Obijiti, Nahar Industrial, those were argued. Here the situation is, I am not.
No, but sir, that's not the larger bench judgment. That is not the larger bench judgment. What Mr. Ghosh is relying on the larger bench judgment, right? Larger bench judgment has held suit is maintainable, right? Suit is maintainable. Now, your endeavor would be to distinguish that larger bench judgment in your own way, whatever way you want to distinguish.
Absolutely, my lord.
So that is no more important.
Absolutely, absolutely. I perhaps I have been able to understand what is falling from your lordship. Suit, when it's a counter claim, certainly it's maintainable. It
is the choice of the
borrower. It is the choice
whether
of the
to go by way of counter claim or whether to file an independent suit on the basis of its counter claim.
Not for a single moment I am saying that if it's a nature of a counter claim or independent claim, it is not maintainable. But a suit, because it's in DRT, two types of proceedings are there. My lord is well aware. Surface action, challenging that a borrower goes and files a Section 17 application under the Surface Act. RDDB Act.
Surface Act is only for the borrower to initiate proceeding. Similarly, RDB Act is only for the bank to initiate proceeding. That's all.
VCK under the RDDB Act. Bank filed original application under RDDB Act. Bank was asking you go and
place koro na muker kache properly place kor baba. Yes.
You go and file your suit in that application only. Now, whether by way of a counter claim or independent suit, whether by way of a counterclaim or independent suit,
That's the choice
that's
of
the choice
borrower.
of the borrower. Now here, my case, the suit that has been instituted in a manner and the claims, that is why I placed relief C and relief D that had been claimed in the plaint. As soon as those have been claimed before your lordship, the framing of the suit gets barred and the jurisdiction of
Mr. Mukherjee, don't repeat your argument.
So
you concentrate on the Supreme Court judgment, VCK judgment, and tell the court how will you distinguish it in your own way. Don't go by those. Those are here, not to worry. You read you just tell me how you will distinguish the judgment.
That clause C. Is the jurisdiction of a civil court to try a suit filed by borrower against bank or financial institution ousted by virtue of the scheme of the RDB Act. I am not at all on RDB Act. My case has got nothing to do with RDB Act.
Where you have read?
My lord, that clause C, my lord, maybe please to find in paragraph 16, the questions have been framed.
16?
1-6, yes. Yes, my lord. Paragraph 16. Is the jurisdiction of a civil court to try a suit filed by the borrower against a bank financial institution ousted by virtue of the scheme of the RDB Act in relation to the proceedings for recovery of debt by a bank or financial institution? My argument is absolutely restricted to SURFACE Act, and I am not making my submission with regard to RDB Act. That's a different proceeding. I do not say that because I have filed an original application under RDB Act, this suit is not maintainable. It is not my case. My case is that since the claims C and D have been framed in a manner and have been prayed before your lordship in a manner that as soon as it has been claimed, the suit gets barred under section 34 of the SURFACE Act.
SURFACE Act, they have not even initiated proceeding.
No, I have initiated proceeding. They have to challenge.
You have exercised your right under SURFACE by issuing 13.2, 13.4 and Rule 8 notice.
Yes.
Right?
Yes.
You are also in the process of proceeding with the cell under SURFACE Act.
Yes.
15 times or 10 times you have attempted, you failed. That's neither here nor there.
Yes.
But the fact remains, you are in the process of selling of those secured assets.
Yes.
Right? So tomorrow, if you ultimately sell, let's say you get an excellent purchaser. You get an excellent purchaser, Mr. Dhruvo Ghosh says, I will purchase. Whatever price is agreed, whatever price is the auction price, whatever way. And somebody purchases. Will there be any bar that pendency of this suit will not allow you to sell or allow them to purchase?
My understanding, subject to correction by your lordship, as soon as I'll be selling the property under the SURFACE Act, it will be interpreted that it's a coercive step because I am exercising my statutory right.
Sir, that is at the stage of Order 39 Rule 1. That is at the stage of injunction, when injunction will be prayed for. Today you are on a demurrer application. You are not on an injunction application.
Well, it seems I am on demurrer.
Today your application
The
is
suit-
under Order 7, Rule 11.
The suit has been framed in a manner. The suit has been, it's not a simplicity that because of bank's ABCD negligence or failure that they are entitled to rupees 100 from the bank. It is not a case like that. It is a case that bank is bound by an OTS that has been allegedly accepted, agreed between the parties. And so, no coercive step, categorically it has been claimed before your lordship that no coercive step should be, bank should be permitted to take any coercive step, perpetual injunction. As soon as they have claimed Section 34 of the SURFACE Act, besides other provisions of other law, Section 34 of the SURFACE Act comes into play.
Why?
No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debts recovery tribunal or appellate tribunal is empowered to.
Any matter within the meaning of SURFACE Act.
Yes.
Right?
Yes.
Now show me from their prayer that any matter within the meaning of SURFACE Act is under challenge. They have not even challenged your declaration of NPA, have they?
No.
Mr. Ghosh?
No. No.
So,
No.
Sure.
No. But kindly see, for the sake of repetition, kindly see the claims in the prayer, claims in the plate.
Yes, sir. Yes.
Decree of declaration that acceptance of confederation by the defendant bank against the enhanced offer of OTS proposed by the plaintiff resulted into a concluded contract. B. Decree of specific performance. Performance of the contract in respect of the concluded contract between the plaintiff and the defendant, thereby directing the defendant bank to accept the remainder amount. My claim is today 315 crores.
Total claim?
Total claim, my lord, I have pleaded 315 crores.
Where have you pleaded, sir?
Paragraph 8 of my application. And it has been denied generally.
Oh, that's all right. Total claim 315 crore.
Yes.
Paragraph 8.
Yes. 317. I'm sorry, 317.77 crore.
317 point?
317.77 crore and odd.
Whatever.
As on 10th July 2025.
You distinguish the judgment, the larger bench judgment.
My lord, larger bench judgment says if someone has to institute a suit independently in a civil court, the provisions of the RDDB Act will not cause any impediment. My case before your lordship, if a civil suit is filed and it causes an impediment in realizing my debt, it causes an impediment in enforcing my right under the SURFACE Act, besides IBC and etc. Under the SURFACE Act, then immediately it gets hit by Section 34. So it's two separate propositions, my lord. So VCK share trading case does not apply in our case.
So what is your submission?
In the Honorable Supreme Court in VCK share trading case had held that a suit instituted by a borrower in a civil court
arising out of RDB Act, RDB proceeding.
Arising out of RDB proceeding or in the nature of counterclaim, etc. He is under, there is no impediment for him to maintain an independent suit. It is not ousted. My proposition There is no, I'm not at all raising any dispute with regard to that proposition. That's settled. My proposition before
You cannot, neither you nor I nor
no,
Mr.
nobody in the country.
It's a settled law.
Nobody. Now, my proposition before your lordship, today, if someone institutes any suit or any proceeding which could be decided by the learned DRT or appellate tribunal, under the provisions of the Surfacy Act, as soon as such proceeding is filed, the same is barred, that honorable forum loses the jurisdiction. The framing of the suit is important. Now, my lord, with regard to there is no pleading whether the the suit is barred by the IBC or not. My lord, it's a point of law. Section 63 is there. It's a law of the land. My lord is aware that
No, I will, the moment one application is brought that the suit is barred by law, I will read the plaint.
Very well.
I will read the plaint.
Very well.
That's all.
Very well.
Then
now, when my lord will be reading the plaint on the last occasion, Mr. Dasgupta has already placed the plaint.
You just distinguish the judgment. For that, if you require to show me anything, you submit.
Now, with regard to the other judgment of 2022,
on what?
Cited by
on what? On what? Which one? 22, the scope 22. Of IBC?
The scope of IBC.
Forget it. You don't have to.
I need not to. Now, only thing, this, I'm sorry, my lord, when
that is for my knowledge and I have read it.
When I was making my submission, my lord, it was my fault that I was meeting my lord's query. 31st December letter should have been placed at that time while I was placing all the
31st December? For
31st
what?
31st December communication that has been shown by Mr. Ghosh before your lordship.
Very well. It's all right. I've seen it. The
yes,
moment I've seen it, doesn't matter who has shown it.
There, the bank never assured that the OTS is final or we are accepting your proposal.
ये बाबा क्या আছে বাহাদুর কে বলো বা পিন্টু কে বলো পাহাড়া বন্ধ করে দিক
The bank never said that your offer.
Yes, proceed.
Your offer is accepted or we are accepting your offer. Bank simply said, we advise you to deposit rupees 1 crore towards the upfront amount.
Let us take it. Bank has rejected. Mr. Ghosh has also taken that. Yes, Mr. Ghosh, that bank has rejected. Then your cause of action arose that it should not have been rejected because it is a concluded contract.
Yes, those letters are the subject matter of the rejections.
That's your case. That's your case in the plaint.
And the last point, whether the proposal of alleged OTS, which is being said to be an OTS or it's an offer, say OTS, it has got nothing to do with the mortgaged land. I'll show only their letter, only 2 sentences from their letter only.
Page?
My lord, page 141.
Yes. One
141.
Yes.
Well, serial number numerical 1, your lordship has seen. 2 and 3. Source of repayment of the OTS amount.
Read on.
A, sale proceeds of the mortgaged land estimated at rupees 40 crores, that is 71% of the OTS amount. So, so it is not that they offered OTS by upfront cash or it will be cash.
That is neither here nor there. Those are all matter of trial. You distinguish this judgment. That's the only work, only job you are required to carry out.
My lord, with my limited wisdom, my lord, I
So you have
understand.
done your job?
Yes.
Thank you. Ashu. Nothing further? No further submissions?
No, nothing in
Not on facts.
not on facts. And,
All right.
and
Chalo.
only thing, equity has been pleaded. That if your lordship directs me.
Mr. Dhruva Ghosh, learned senior advocate, appearing for the plaintiff, has concluded his submissions by citing the Supreme Court judgment, by citing judgments. Full stop. Mr. Saurabh Mukherjee, learned counsel, appearing for the defendant bank, has concluded his submissions in reply. Paragraph. Parties have concluded their respective submissions. Paragraph. On this application for rejection of plaint. Paragraph. Judgment stands reserved. Thank you.
GA1 is appearing as item number.
Item 41. এখন তো নেওয়া হবে না তো till this is decided.
হ্যাঁ, ওটা থাকবে।
বলে দিন
Thank you.
GA1 is appearing as item number 41.
41.
Let me decide this then.
Then let it go
Paragraph.
out of the, otherwise get dismissed
Paragraph,
for
paragraph.
default.
কে করবে dismiss? Paragraph. দেখুন, since the judgment stands reserved in this demurrer application, all connected applications, the hearing in all the connected applications arising out of the same suit stands adjourned for the time being. Stand hobe, applications stand adjourned for the time. কি আর লিস্টে দেবে না? ওনারাই মানে এই ডিপেন্ডিং আপন দি রেজাল্ট, না? যদি সুট থাকে তাহলে ওনারা মেনশন করবেন।
My lord, I am appearing for the defendant bank in the matter. The application is of my learned friend
For
No, seeking-
disclosure of additional
Taking
documents
leave to produce additional document.
plaintiff,
Yes.
by the plaintiff. I am
you are the
objecting.
defendant.
I'm the defendant bank. I'm objecting. I would like to use an
affidavit.
affidavit in opposition.
It's under order amended order 11.
Order 11.
Yes.
Rule 9 and
One.
10.
Yes, rule 1, sub rule 9 and 10.
9, 10.
No, order 11, rule 5.
Order 11, rule 1 is disclosure and
Arey, এটা কি
discovery of
দিবে?
documents.
Today morning I have delivered one judgment.
Yes, I was there.
Oh, you have heard that.
Yes, I have
So
heard
wait
that.
for that. Let it be.
But that should probably not have any bearing with regard to this, because I'll tell your lordship why. Each fact is different to the matter concerned. Now here, what has happened, I'll just briefly indicate. Both the parties had filed their suggested issues. At the stage of discovery inspection, some documents were shown in original, over and above what was already disclosed in the plaint. So my learned advocate on record was there. He was present. He went. But when they went and filed the judge's brief of document, at the time of bringing it on record, they tried to bring on record all those new documents as well. So at that stage, I took that. They tried to bring that, yes, plaintiff tried to disclose, bring on record in the judge's brief of documents,
That
the
new
additional documents which were not forming part of the plaint.
Plaint.
Yes, or no indication was given in the
That
plaint
it is in
also
their
that,
possession, but due diligence, no, not to be.
yes, nothing
could not
of
be
that sort,
produced.
nothing could be
The
produced. at that
declaration is
stage.
not there.
That
in
in
terms
the
of
declaration also, that was not mentioned,
so
similar to what
in terms of
was
rule 1, declaration is not there.
Yes, declaration is missing. In the declaration, it is not stated that they were not in the custody. On the contrary, in the application where they have now come up with, they have said they were all along in possession because the concerned person has left. Therefore, they could not trace it out. That's the only defense or whatever the reason
No, that's not
that
the only
has been
ground.
given.
That's not the only ground.
Whatever the ground
That is her version,
yes,
Mr.
that's my
Tiwari.
submission. My learned friend will show from his application what the actual version
No,
is.
no, he will get his
Yes.
turn. Not to
So
worry.
at that stage, I had objected, and because I said that it's not a matter of right, it has to be by way of obtaining leave,
Leave
and
and
provided
subject to the satisfaction
of the court that
whether the reasons are cogent.
whether the reasons are cogent and whether discretion should be exercised by the court on the basis of the reasons disclosed. So now it is for my learned friend to satisfy your lordship what the
In the
reasons are on
morning,
the
I
application.
dictated one sentence I can remember. It is the perception of the court. There is no straitjacket formula.
Yes.
And the perception varies from one
yes,
court to other.
And
Depending on the
there
fact
has to be a
situation.
foundation in the plaint for the new documents. That, according to me, is missing. So I would like to use an affidavit in opposition. I
So
haven't
this is
used
appearing for the first time.
Yes, it is appearing
Come
for the
on.
first time. Kindly let me
You
kindly
should
allow
have
me
said
to.
it
Yes, I wanted
at
to
the
file an
threshold.
affidavit. I submitted probably. I could not be heard.
Okay. In Re GA, it's one single
GA2
application appearing
GA
or
com
multiple?
GA com 2.
লিস্টে কটা আছে? একটাই আছে। ইনরে GA 2 or ইনরে GA
com
IAGA com 2 of
25.
2025 paragraph. Mr. Moti Tiwari, there's something in Moti
Sagar.
that is I'm missing. So sorry. Mr. Moti Sagar Tiwari, learned advocate appearing for the plaintiff, submits that this is an application filed by the plaintiff for disclosing certain additional documents which have not yet been brought on record on the grounds mentioned in the application paragraph. MS Shuchishmita Ghosh Chatterjee, learned counsel appearing for the defendant bank, sole defendant?
Yes.
Has denied and disputed the submissions made on behalf of the plaintiff, and she prays for an opportunity to file affidavit. Paragraph. Considering the above, comma, affidavit in opposition shall be filed, come on or before aje koto?
It is 19th.
December 17, 2025. Affidavit in reply, if any, thereto shall be filed by January 15, 2025. Paragraph, the matter shall appear under the heading adjourn motion in the monthly list of February 2026.
I don't. Grateful to yours.
এই ওইটা 5 বলেছি ভুল করে 2026 January আর February 2026. Thank you.
I don't.
Item number 6. Global
Item 6, my lord, I appear on behalf of the plaintiff petitioner.
কোনটা?
Yesterday, my lord.
No paper, it is written.
Lord, it has arrived, my lord.
I know. So wait for the day, come tomorrow. Passed over for the day. Because the other side doesn't know, na?
My lord, one thing, my lord, kindly. My lord, 2 times attempts have been made to issue summons. My lord, they have not received. One was item.
Come tomorrow. Next.
Grateful.
ওই নোটটা তুলে দেবেন। Next.
number 7.
Lord, this is my application. I seek to move it ex parte. I'll tell your lordship the reason why. My lord, I had obtained the 12A that day. My lord, I had shown that the liquidator in collusion with the bank has, I don't know whether they have still
What is the
withdrawn.
fact?
I'll tell your lordship. I'll just. The company, there was a company called Recon, whatever. Engineers Private Limited. But may I just tell your lordship the facts briefly?
Just give me an outline.
Just an outline of what happened. They were into
two individuals are the plaintiffs.
Two individuals are the plaintiffs. They were the three individuals. They were the guarantors of the company. The company was in the business of construction and had.
Now, let me see first, one by one, Mr. Bhattacharya. Defendant number 1, the respondent number 1, respondent number 2 are the two banks.
Yes.
Who's 3?
3 is the liquidator.
Acha. So the company has gone into liquidation.
But
represented
it's
to
the final
liquidator.
order of liquidation.
That's no issues. No issues. So why two banks?
My lord, because
separate loan transactions.
Yeah, it was a consortium.
Consortium. Very good. Consortium loan was advanced.
Loan was advanced.
You three stood as guarantors.
Guarantors, mortgage properties, very well. Now
executed the guarantee documents.
Executed the guarantee documents. Now they start writing to my clients, where I was executing. There were some default or something in payment of interest. They start writing, and on that basis, my contracts get cancelled. All my contracts. After doing that,
no, they were writing to whom?
To my employers. My employers. Ministry of Defense. I had a 800 crore project, hospital project in Pune. They wrote to them that this company is bankrupt. Do not.
Company is bankrupt.
No,
company is now in liquidation.
I'm telling your lordship. This is much before.
After, but how? Don't get excited. Slowly. How these three plaintiffs, apart from being guarantor, are related qua the borrower? Apart from being guarantors?
They were the directors of the company.
That's right. So they were the directors of the company, executed guarantee.
Guarantee and mortgage properties.
Your properties are mortgaged.
Yes.
Or the company's property.
Our personal properties. Our personal properties.
Properties are mortgaged. So the company has gone into liquidation. Then, to whom they are writing letter?
No. This is much prior to that. May I come sequence-wise? This was sometime around 2014-15. They write to my employers.
Employer means the company who has gone into liquidation.
My company was a contractor. They would make buildings for Ministry of Defense.
Contractors.
Contractors. For contractors. We were the contractors. They are employers. We were contractors. They are termed as employers in a construction contract. So my owners, as I would say, owners or employers, and my contracts were cancelled. After those contracts were cancelled, they renewed the cash credit facilities in 2019. They renewed it. If I was a delinquent, if the company was delinquent, why would you even renew it? My lord, a cash credit is renewed only when the bank is satisfied that this company is in a position to pay me back, to service my interest, to pay back my principal. After that, what I did was I filed a suit against them, against these two banks. I know the company, which has now gone into liquidation. They did not file written statement. There are orders from Calcutta High Court and said.
So you are still then directors of the company?
We were directors, no doubt. Now the company goes into. We file a suit. Our Section 7 is filed in the NCLT. CIRP process does not go through. Liquidation comes in. There, the liquidator, I will show it, shocking. Liquidator says I had filed a suit, the company, that this suit should not be withdrawn. The banks, who are the only stakeholders, they said, no, this should be withdrawn. Though we are the biggest beneficiaries of that suit. Because if that suit is won by the company, that money will come to us.
Sir, I fail to understand. If the company in liquidation, prior to its liquidation, was the suitor, plaintiff, against the two banks, which is now equivalent to the liquidator. So
yes.
Let us take the liquidator as plaintiff today.
Yes.
Unless the plaintiff withdraws the suit.
Yes, that's what they have done.
The banks.
That's what they have done. That's what they are doing.
So you're making out a case of collusion.
Collusion and fraud.
Banks and the liquidator.
Bank and the liquidator. That's exactly my case. So
then
today they are trying to withdraw, or maybe they have withdrawn. I am not, because I won't be aware of it. And now they're the banks are now trying to enforce these guarantees and sell off the mortgage properties. My lord, your lordship knows that a surety steps into the shoes of the creditor.
If the terms of guarantee contract altered, surety stands discharged.
Now, no, also, if the creditor does something which jeopardizes the right of the guarantor to recover that money, even then it gets discharged. My lord, I will rely on
without
the
consent of the guarantor.
Yes, I'm grateful to your lordship. Absolutely. No, my lord, I will just show few documents to your lordship.
One second.
No.
Show me the Schedule A.
Schedule A to the
your prayer.
Schedule A to my
37.
Yeah, it's page 37. And this properties your lordship will find. সবকটা বেঁচে দিয়েছে except for the কোনটা ছিল? দাঁড়াও আসছি, আগে করে আসছি।
What is the averment you have made about your apprehension on property?
Yes, my lord, I have said so. The urgency have.
Urgency is different. First, yes, whatever. Wait, you want
my lord, paragraph 37. I'm sorry, my lord, the page is at page 32.
Yes.
And also, if your lordship kindly considers paragraph 31 at page 27.
1 second, sir. Thirty-one.
31 at page 27.
But the NCLT is not in session of the matter.
My lord, but this declaration that I stand discharged because of such act, my lord, the NCLT does not.
And that's all right. That's fine.
That's over the NCLT has every right over the company in liquidation.
And over the liquidator appointed by it.
That's a different cause of action. Here my cause of action is as a surety. Your fraud, collusion will affect my rights, has affected my rights, and I therefore stand discharged. My right to recover from the company, which is the liquidator himself. I will show, my lord, what is the stand of the liquidator. After that, how did he do a volte-face?
Mr. Bhattacharya, I shall not pass any ex parte order. I am making it very clear on these facts, because after all, at the end of the day, when the default occurred, you had a fiduciary liability also.
No, I did not.
As
a guarantor, yes, it's
directors.
coextensive.
As directors, no. First as directors, fiduciary liability, then as guarantors, coextensive.
Yes.
So I will not pass an interim order
Directors do not
without
have
hearing
a
them.
personal liability so far as
No,
banks claim.
without hearing them, I will
But
not.
may I
do.
just show one document? One document.
I am keeping it even tomorrow if you want, tomorrow or day after, I don't mind. But you have to serve and come back with affidavit of service.
But can I come back then on Monday?
Monday?
My lord, only one thing I should indicate to your lordship. My lord, the plaint which has been filed.
I tell you, because your Jawaharlal Nehru Road is the Indian Bank, Punjab National Bank is Hemant.
Day after I have some difficulty, my lord. My lord, only
No,
thing.
I don't mind for that. Whenever you want. That I don't mind for that.
Service.
And the other one is also Western State.
My lord, keeps it tomorrow.
You tell me when you are available. I don't mind for that.
Oh, it will reach, if it sends by speed post, it will reach on Friday.
I don't mind, sir. You give me
Monday,
a date.
Monday.
You give me a date, I will
Monday. My lord, only thing I would, my lord, like to indicate to your lordship. My lord, we had this, your lordship, with your lordship's vast experience in this side of the knows how these plaints are prepared in haste and all. My lord, by mistake, the plaint which has been of Andaman suit, which has been annexed to the petition, which is annexure at page 236, volume 2. My lord, this was a draft copy of the plaint which has been unfortunately annexed. Now we have, my lord, this is the embossed copy we have.
That I cannot do like that. You have to come up with an application, but that can wait.
No.
That can wait. You keep sufficient copies on the for the next
My lord
day.
will kindly record, because they will then come and say that.
Not to worry, I will record your submission. I'm recording your submission, but I will not grant leave like this. You have to come up with an application for that. It's a commercial suit, so I cannot do that. But I will record your submission. Ashun. The plaintiffs stroke petitioners claiming to be guarantors of a loan transaction with a borrower company, namely
borrower banks. My lord,
borrower company, namely
Recon Recon Engineers
India Private.
Spell out.
India Private Limited.
Spell out. Recon.
REACON.
REACON.
Engineers.
Engineers.
Within
Any apostrophe?
No.
Engineers.
Within bracket India.
Then?
Within bracket India Private Limited.
Which has gone into liquidation and now being represented through the liquidator, being the third defendant / respondent in the suit. Defendant number 1 and 2 are the consortium banks, are the consortium, CONSORTIUM. এটাকে বলে consortium. Consortium banks wherefrom the loan was advanced.
The loan was actually disbursed by Allahabad Bank. The name has subsequently changed to Indian Bank.
It's merged with it.
It is merged with Indian Bank.
The predecessor in interest of the defendant number 1 was the Allahabad Bank, who was at the relevant point of time a member of the consortium. Full stop.
And my lord, the defendant number 2, my lord, its earlier was United Bank of India. It has merged with Punjab National Bank.
The predecessor in interest of the defendant number 2 was United Bank of India, which was also a member of the consortium. Full stop. Paragraph. First paragraph. The plaintiffs allege that in collusion and conspiracy between the banks and the respondent number 3, the guarantees executed by the petitioners are sought to be invoked by practicing fraud. Poster. Today, accordingly, the petitioner prays for an immediate order of injunction. Poster. Paragraph. Today, Mr. Rudraman Bhattacharya, learned senior advocate, appearing for the petitioners, moves the injunction application ex parte. Paragraph. Considering the issue involved in this injunction application, this court is of the view that no order can be passed at this stage ex parte, and the interlocutory reliefs claimed by the petitioners shall be considered upon serving notice on the respondents. Paragraph. On the prayer of the petitioners, paragraph. On the prayer of the petitioners, the matter shall appear under the heading new motion.
New motion.
New motion. Tell me which day?
24th.
On
24th.
November 24, 2025. Full stop. The petitioner shall serve notice along with a copy of the injunction application upon the respondents and file affidavit of service on the returnable day.
Great.
First. Thank you.
Great.
Newspaper application. Item number 8.
Lordship, I beg to appear on behalf of the defendant petitioner.
I am Millard.
My application praying leave to file my written statement taken out beyond 30 days, but within 120 days. In fact, the writ of summons has been taken out on the 120th day itself. And the petition was also filed on the same date.
Writ of summons taken out?
Yes, yes.
Writ of summons.
Master summons, Your Lordship. Master summons.
My lord, I am Millard, led by Mr. Rohit Banerjee. Millard, he is Millard on legs, Millard on in another Millard. If your lord.
Master summons taken out on the 120th day, and the application was also filed on the 120th. And the written statement was affirmed on the 119th day, Your Lordship. Now there is one confusion regarding this matter. I have calculated my calculation from
all right, not to worry. Ashun.
But tomorrow I will be having some difficulty.
Listen to my order.
Yes.
The master summon has been taken out by the defendant, inter alia praying for extension of time to file written statement. Beyond 30 days, beyond the mandated 30 days, but within the mandated 120 days from the date of service of writ of summons, as provided under the amended provisions of Rule 1 to due to order Roman 8 of CPC. Paragraph. Mr.
Shuman Majumdar.
Mr.
Gaurav Purokayastha.
Gaurav Purokayastha, learned advocate, appears for the
Defendant. Sole defendant.
Defendant, applicant, stroke applicant. Mr.
Shuman Majumdar.
Shuman Majumdar, learned advocate, appears for the plaintiff. Considering the averments made in the application, the প্রদ্যুৎ শোনো এবার কোনটা মাস্টার কোনটা কি আমি বলিনি, the office of the deputy sheriff shall file a report disclosing the date of service of the writ of summons upon the defendant on the next day.
Lordship, only one fact which I omitted to mention before your Lordship. A second writ of summons was served to me by the sheriff's office on an application which was moved by them.
Writ of summons or summon oblique
And Miller through
summons.
email.
In an application filed by them where they had admitted that the initial writ of summon was not.
You have annexed that application.
Yes.
You have annexed that
Yes,
application.
and a coordinate bench's order is also there.
All right. Wait. কি বললাম? Averments. Shall file a report. Summon have singular stroke summons. Next day. Paragraph. Similarly, the office of the learned master shall also file a report disclosing the date on which the master summon has been taken out and or the application has been filed. Paragraph. The matter shall appear under the heading New Chamber Application. On আজকে কত
19th.
December 4, 2025.
Lordship, I had prepared a small list of dates for assistance.
Keep it with you. It's very essential.
Yes.
Bring on that day.
I'm so grateful to you, Lordship.
Statement file হয়নি তো?
No.
হয়নি তো?
I know the view of this court. I didn't take the risk of mentioning it because the application was not on board.
Don't mention.
I'm so grateful to you, Lordship.
Thank you. Next.
Item number 9. My lord, in item number 9, my lord, I'm appearing for judgment debtor. My lord, kindly once look the order dated, my lord, the 9th September 2025, my lord.
May I, my lord? My lord, I am for the decree holder. The decree was passed in the year August 2014, my lord. It was at that point, there is no commercial code, my lord. So, unfortunately, we have filed it before the commercial code.
This is decree for what?
Decree commercial dispute, but
money suit.
Money claim.
So the decree has been numbered as e-com. That's right. So its proceeding has been numbered as e-com.
When the suit decree was passed, there was no commercial code, my lord.
So cute.
Now they have raised the point, the award holder, that I have to file it before the non-commercial code, and it has to be.
Let them raise the point before.
My lord, my lord, even on the last occasion.
You're still insisting on that point.
My lord, because as per my lord,
if you still insist on that defense, first you take that defense, let me deal with it. And if you don't take that defense, you argue whatever you want to argue. Tell me.
My lord, the actually
What is
this
the quantum of money?
Quantum amount 25 lakhs and odd with interest. 25 lakhs plus
10 lakhs on next week, in the next week.
my lord, we have two things, my lord. First of all, none of the assets is within the jurisdiction, my lord.
All right, first you deposit 10 lakhs, then I will see.
My lord, even the order was passed in a non-commercial when there was a no commercial division, my lord.
Absolutely. So the decree will not be executed
No, my
by
lord,
the commercial court.
no,
Would you deposit 15 lakhs? 10 now has become raised to 15.
My lord, I have
From
to take
this point.
My lord, even
Would
my
you
lord,
deposit?
My lord, in this issue, my lord, the earlier in another matter, my lord, the Justice Apurva Sinha Roy, my lord, the
Sir, if you deposit, you tell me, or I shall issue a warrant of arrest.
My lord, without instruction, my lord, kindly give. My lord, then I will come back on next week, my lord. Kindly.
No, next week. Come tomorrow.
My lord,
deposit.
I
Then
have to
we will
take
see.
instruction, my lord. Kindly give me a little bit time, my lord. So
no question of little time. You have to go and take instruction. You have to deposit by next week. 10 lakhs.
my lord, I will come.
You have to pay 10 lakhs.
I will come with instruction, my lord. I will come back with instruction.
10 lakhs if you pay by next week to the decree holder, then I shall consider some easy installments thereafter.
My lord, I will come back with instruction, my lord.
But 10 lakhs may what come?
I will come back. Back with it.
So, sir, you take instruction. 10 lakhs by next week, your client has to pay. Right? Then ask for installments. I will grant you easy installments.
I will come back with instruction.
Passed over for the day.
Kindly fix a date. Any date may be fixed, my lord.
Tomorrow.
Oh, great.
Matter will run in the list.
Grateful.
Passed over for the day.
Grateful, lordship.
Item number 10.
Take instructions, sir. Take
In this
instructions.
matter, I am for the judgment letter, my lord.
I am for the degree holder.
But I am for the judgment letter. But this is basically a judgment, execution of a dismissed suit, my lord.
Dismissed suit. Is there any valid decree?
My lord,
Yes,
decree.
yes, degree, my lord.
My lord,
money decree.
No, my lord, it
Money
was
degree,
no, it was not a. My lord, I'll explain what.
Let
was
me
the
see the decree. Your
Yes, yes.
explanation will not do.
No, my lord.
After decree, executing court cannot go beyond that.
No, I'm not asking, my lord. I'm not praying for suit.
My lord, amendment application has been
What
filed.
amendment?
Amendment
My
of
lord, in
tabular
the
statement.
tabular statement, they have put the prayers of the plaintiff, my lord.
They have
So they have amended that.
They have not filed any objection.
Where is the amendment application?
Application is there, my lord.
No, it was allowed.
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 It was already allowed.
You have carried the amendment.
Yes, my lord, carried the amendment, but my client is not here, so my lord, reaffirm is not here. Complete, my lord. Reaffirm not complete. My lord.
What reaffirm?
Reaffirm of the amendment application before the department.
My lord, I'm explaining.
Kindly 1 week
My
time.
lord, actually, there was, my lord, there was
Kindly-
some amendment
kindly-
which they have made, which was allowed. They have amended it.
Decree for money decree.
My lord, it was money decree.
But how much?
My lord, 8 lakhs.
8 lakhs.
No, my lord.
8 lakhs plus.
21 lakhs, my lord.
My lord.
Array, whatever amount he is saying, let me put that first.
My lord, there was.
কলম 10 টা ও এ তো ভুল ছেপেছে কলম 10 এ
হ্যাঁ
এটা তো ডিগ্রিটা আছে দেখি
Yes, my lord, decree judgment both are
কপিটা আছে
kindly 1 week time. My client will be reaffirm this matter.
And there are some, my lord, incorrect averments in the affidavit. My lord, I'll file objection to that.
Yes. All objections will be taken.
Well,
First payment.
I file my reply.
My lord, if there is direction for payment, then only, my lord, the question comes.
I'll file my reply.
The money neither belongs me to nor him.
No, my lord. It is my money, my lord.
No, it has been held, my lord. It is not his money. Paragraph 15 of the judgment.
You are for the bank.
Yes.
So you will release. I will direct you.
My lord, may I explain the situation, my lord? That money does not belong to him.
No,
and
no,
it
my
has
lord.
been-
This
my
is
lord,
my
if-
money,
if-
my lord.
my lord, if you let us,
This
my
is
lord.
my
After
money, my
decree,
lord.
we will argue that.
No, my lord, I'm not arguing that. The decree is that whatever the money he belongs to him, take that money.
No,
No. Let us see, read the decree.
My lord,
The
lordship.
suit it is ordered and decreed that the suit being such and such
Yes, my lord.
be and the same is hereby dismissed on contest,
Yes,
and this court do not think fit to make any order as to costs of this suit. The incidental to the application. Acha, the plaintiff company, the PLA such and such, shall be at liberty to withdraw the amount deposited along with
Yes, my lord.
accrued interest
Accrued interest,
with
my
the
lord.
defendant bank, UCO Bank,
Yes, my lord.
pursuant to the order of this
Yes,
court dated 15th
Yes,
June in the year 2011, passed by such and such, and the same is further ordered accordingly, and corrected application disposed of accordingly, and interim order stands vacated.
My
So
lord,
release the amount.
Release
Lord,
the amount, my lord.
see that order, my lord. What was the order? It is annexed, my lord.
No, my lord.
That order, my lord, it is already annexed, my lord.
Show me, show me.
My lord, it's
Which
in
page?
it's page number 10, my lord.
Accrued interest is, my lord, 21 lakhs.
My lord,
Now,
it is subject to the result of this suit,
mm,
my lord. And that also, my lord, there were to
Subject to the
21
result of the suit.
Yes, my
The
lord.
suit
And,
is
and my lord, they are furnishing a indemnity bond
No,
as
my
per
lord.
the bank. They have not furnished that.
my
for the moment
order
the
is not
plaintiff
there.
would be entitled to obtain refund
Refund, my lord. Yes.
Yes, ma'am.
that remains on account of the plaintiffs,
Plaintiffs, my lord.
depositors with the defendant, subject to the plaintiff executing an indemnity bond
Yes, ma'am.
in the form suggested by the bank within a period of 7 days from the bank making over form. The bank is afforded a period of 1 week for the date to hand over the appropriate format.
No format
Have you
is there.
given?
Yes, my
No
lord.
format, my lord.
You will again give it.
I'm sorry.
Don't worry. Executed by the plaintiff in the event. The plaintiff will be entitled to receive the sum of rupees 841 from the defendant, subject to condition that fixed deposit of such amount has to be opened by the plaintiff with any branch of the defendant
That done.
and may be converted convenient to the plaintiff. The deposit will abide by the result of the suit. Now the suit is dismissed.
Dismissed.
Entire amount will go back.
Go back.
My lord, suit is dismissed.
Yes.
It was their claim, my lord. Their claim is it is stated
My
that
lord.
they don't have
No,
any
Then
claim.
what
No,
happened? Then what is the direction to give to the?
My lord, unless they give the indemnity bond, what was the
They
format?
will give it.
My lord, if they give, I will find. I would have given at that point of time. They are not able to give
All
that.
right.
Uh,
Give the indemnity form.
My lord, I have already given. I can give that again. my lord.
supply me the indemnity bond.
Yes.
I will do so.
Draft copy of the indemnity bond.
What about the annex amendment application?
Amendment application is there, my lord. One tabular statement and announcement. As amendment application is there.
It is disposed of.
Yes.
Disposed of.
Yes, sir.
Show me the order.
That's 29th October. It was formal in nature, my lord.
Order.
Yes, amendment carried out.
Amendment carried out.
And if your lordship allows me 1 minute, my lord, I
Which
clarify
one
this.
you? The sign signature has not been done.
Department is sent me told me that a reaffirm be required, my lord.
And the affidavit which has been annexed with the that is departmental facility thing, my lord. My lord, if your lordship allows me, my lord, 1 minute, I can explain the situation, my lord.
Ashun.
My lord, may I say something 1 minute?
Nothing. You just act in terms of the decree.
My lord, in the decree, my lord, it cannot be done, my lord.
I will make it to be done.
Why I say, my lord, kindly hear me 1 minute, my lord. There was an indemnity clause in which they have to indemnify that some banker's checks were not handed over to the creditor, which they are now said that it has been handed.
The decree has already been made on decree dated.
My lord, it is 17th September 2000. No, it is reserved down. That is reserved down. Delivered on 30th April 25. 30th April 25.
April 30, 2025 কি বললাম ডেটটা বোল্ড করবেন পোস্টার paragraph subsequently by an order. Show me the order.
No, it was not subsequent, it was prior to. The order was, my lord, 15th June 2011.
By an order, subsequently by an order dated October 29, 2025.
I'm sorry.
The amendment as straight forth in column 10 of the tabular statement has been allowed. And the procedure was directed to be completed. And the relating procedure was directed to be completed. Full stop. Paragraph. The record shows that the tabular statement has been amended in terms of the decree, but learned, but Mr. Your name?
Mr. Topon Nag Chaudhary, my lord.
Topon Nag Chaudhary, learned advocate appearing for the plaintiff decree holder submits that some procedure is yet to be completed in the department. Paragraph. The decree says, paragraph, the decree states that the amount lying deposited with the defendant bank, UCO Bank, defendant UCO Bank, shall be released the fixed deposit lying amount na, the fixed deposit lying with defendant UCO Bank shall be released in favor of the plaintiff subject to furnishing shall be released na kore shall be refunded to the plaintiff subject to the terms and conditions mentioned in the order dated June 15, 2011 at page 10 to the execution application.
It is, my lord, withdraw the amount deposited.
The relevant portion from the order dated June 15 paragraph 2011 is quoted below.
Only the amount deposited was to be withdrawn, not
No,
the entire. My lord, kindly see paragraph 16.
Interest, my lord.
Whatever is there is there.
Yes, sir.
Lord, I beg to appear, Lord. I'm sorry, my lord. I was trying to enter, my lord. Unfortunately, I could not.
Rahul Kormakar. One like that.
Quote 12, page 12, quote 1. কি বললাম Full stop. In view of this, Mr. Your name, sir?
Shailesh Mishra.
Shailesh
Mishra.
Mishra, learned advocate, appears for the defendant bank. Defendant UCO Bank. In view of the above, the matter shall appear under the heading New Chamber Application on December 11, 2025. Paragraph. The bank is directed to furnish the necessary indemnity bond, the format of the necessary indemnity bond to the plaintiff positively within 7 days from date. Full stop. The plaintiff, upon filling up the said form, shall deposit with the bank in the meantime. By filling up the said form, shall deposit with the bank in the meantime. ঠিক আছে আর মাথার উপরে লিখুন কি হলো what's your name? You said
My name is
Tapon Kumar such and such, led by Mr.
Rahul
Kormokar. Rahul Kormokar, learned advocate, appearing virtually for the plaintiff, decree holder. Sure.
Well, I'll hand over the format, my lord. I've already handed over or re-hand over it, my lord.
Do it, sir. Do it.
Before your lordship rises.
Lordship will grant.
Any extension of entry order?
Yes, my lord. Expiring today, item number 25.
25?
Yes, my lord. This is the last order, if I may. I'm mentioning upon notice.
Lord, I am for the defendant.
Mr.
Shourojit Dashgupta.
Shourojit Dashgupta, learned counsel, appears for the petitioner, plaintiff, oblique petitioner. This is the
That group of
section 8.
companies.
Yes, this is the section 8. Section 8.
Yes. The judgment is reserved.
Yes.
All right. কি বললাম? Mr.
Asif Hussain.
Asif Hussain, learned advocate, appears for
For the defendant.
how many?
One defendant.
For the defendant, oblique respondent. Paragraph. The interim order last extended on September 18, 2025 survives till today. And accordingly, comma, the same stands further extended till February 18, 2026 or until further order, whichever is earlier.
Grateful.
Extension of interim order.
An unusual 21, I don't know, 20.